Good morning, everybody. Before we get started, episode 300, and we were talking in the pre-show. I never expected when I started this thing a little over a year and a half ago that we would develop into what we are, into the community that we are, the friendships that have been forged, all of that. It means the most to me, and I want you all to know that. Before we even get going here today, Lindsay, a $30 super chat. Ashley, 10 gifted memberships. Wahoo, a $3 super chat. You guys are amazing. Thank you so much. As I say, let's roll, nerds. Good morning, everybody. Happy Super Friday, TCF Live, episode number 300. Good to have you all here. Michael, thank you for gifting a membership. Tot, thank you for gifting 5 of them. Appreciate you both. Judge Anzalone, having heard that I might have to start the day in the Wayback Machine, suddenly goes online, so let's start our day with her.
960FH, 2024-21962FH, 2024-21963 FH, in the matter of the people of the state of Michigan versus William Sean Byram. I have Salvatore Malaro appearing on behalf of Mr. Byram. This is the date and time set for sentencing in this matter. Mr. Byram, I'm going to open up a breakout room so that you can have a moment to speak with your attorney. And when you get the invitation to join, go ahead and join. If you can't figure out how to get out of it, don't worry. When Mr. Malaro comes back, I can bring you back as well. So I'm getting the right number. Why do I have 2 Joes and 1s? That's not fair. Okay. I'm going to change your screen name to Byram, sir, just because for some reason I have 2 Joes and 1s. Okay. Here we go. And there we go. There you go. Join that breakout room.
Thank you, Judge.
You're welcome.
Tim, thank you for gifting 5 memberships. Appreciate you very much, sir. Barbara, thank you for $10. Kitty treats for Ellie, the co-host. We love you too, Ellie. Yeah, Ellie is the whole reason that we made it to 300 episodes. Let's be honest. It's got a hell of a lot less to do with me and more to do with her. So thank you, Barbara.
All right. Miss Rowe, can you hear me?
Yeah.
All right. We're just waiting for Miss Underwood. She's talking to a different client right now, so just be a minute, all right?
Okay.
So, folks, good morning once again. Just to explain, we're going to hang here with Judge Anzalone despite it being a little bit quiet. As is typical for a Friday, slow starts in the courts, and most of them that are running are doing landlord-tenant, which quite honestly is more boring than listening to silence from Judge Anzalone. So we're going to hang here for just a few minutes until she gets the next contestant queued up.
Good morning.
Hey, it's Anna Marie Anzalone. I'm sorry to bother you about this, and I know you guys are busy. I have an attorney that's in between hearings in Jackson County that's zoomed in to take care of Mr. Lake. I wondered if I could switch out like Alexia Rowe or somebody to see Mr. Lake,
Yeah, of course.
because I don't want to lose the attorney. Thank you so much.
Yeah, of course. I'll let them know in the middle.
Okay, thank you. Bye.
Yep, bye.
Thank you, Judge. I appreciate that.
Not a problem.
All right, Eric complains that I haven't sent him the terms of service regarding pet reactions. It is in the terms of service that if you do not receive the terms of service, we are held harmless for you not receiving the terms of service. Good morning once again, everybody. TCF Live. Slow start for Friday, not all that unusual. However, we have another, well, let's hang tight here a second. No, it looks like she's still going to be a minute. We have another option. Let's go up to Lansing, Michigan. Judge Flores looks like he's got some stuff going on.
For misdemeanor domestic violence 93-day with the dismissal of counts 1 and counts 2. That offer will remain open until the beginning of the preliminary examination next week.
Right. Mr. Anderson, is that a fair statement? We're going to leave on for prelim on June 5th at 8:30.
That's correct, yeah.
All right. All right. So we're leaving on for the previously scheduled prelim for June 5th, 2026 at 8:30. That would be next week at Friday at 8:30. And the terms in the offer have been placed on the record. Anything else for the record in 26-01352, Ms. Fortunico?
Not for the people.
Mr. Anderson.
Just confirming for my client, Your Honor, that is in person.
That is in person. So it'll be live in person on the 6th floor of City Hall of Lansing. All right, Mr. Bregman?
Yes.
All right. We'll see you there. We'll see you here at 8:30. Thank you for your appearance today. You're all set, Mr. Bregman.
Thank you, Judge.
Yep. Have a good one. Have a good weekend.
We'll see you, Mr. Anderson.
See you, Judge. Thank you. Have a good weekend.
We are ready on Rembert.
Rembert. Keith Rembert.
There's going to be one I need to consult. Don't say.
Oh, let me move Ms. Robinson. So Ms. Robinson, I'm gonna put you in with Mr. Wicks, and when you're done there, you come back and I'll put you in with Mr. Allred.
Thank you.
Let's go. All right, so we're on the record in docket 2601-341. That's people of the state of Michigan versus Keith Rembert Jr. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Doyle.
Yes, good morning, Your Honor. Dan Doyle, appearing on behalf of Mr. Rembert Jr. And just for the record, I'm standing in for the attorney of record, Michael Oakes.
Michael Oakes. All right. Thank you. And sir, you are Keith Rembert, is that correct? You'll have to either get closer to the mic because I can't hear you.
Yes, sir.
Okay, perfect. And you can hear me all right, Mr. Rembert?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. At this time, we're asking that the matter be left set for preliminary examination.
And is that a fair statement, Mr. Doyle?
It is, Your Honor. It's a fair and accurate statement, Your Honor. We did request some additional discovery, but besides that, I want to leave it set.
All right. So we are leaving on for prelim next Friday at 8:30. So Mr. Rembert, that prelim will be live in person on the 6th floor of City Hall of Lansing. All right, sir?
Yes, sir.
All right. Anything else for the record in docket 2601-341, Ms. Fortuna Gill?
Not for the people.
Mr. Doyle on behalf of Mr. Oakes.
No, Your Honor, thank you.
All right. Mr. Rembert, you're all set. Thank you for your appearance today.
All right. Thank you, Judge.
And you want to go on? I don't know.
Do you want to go on, Brandis? Are you ready?
Yeah.
We can go on, Brandis. Right, because we need the PSI.
All right, so we're on the record in docket 2501-751. That is people of the state of Michigan versus Lee Brandis. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Lee Brandis, who is standing to my right. Mr. Brandis, if you can please state your first and last name for the record.
Lee Aaron Brandis.
All right, thank you. This is the time set for a sentencing in the matter. The last I have on this matter is that Mr. Brandis was failed to appear on August 18th, 2025. And then it was rescheduled for August 29th, 2025. So we don't have a PSI.
Yes,
Is that
Your Honor, if I
your
may.
statement? You may.
So my understanding is that is correct. There was the initial failure to appear for the PSI and for sentencing, at which point he was put in bench warrant status, I believe on I believe it was actually December 9th, and was in bench warrant status until he was picked up, I believe, on or around early to mid-April, and arraigned on the bench warrant, at which point he was, I believe, remanded for the PSI to be completed. I did end up speaking with him via Polycom from the jail. I went over that process with him, how and what was likely to happen. However, according to the probation department, who I just spoke with downstairs, it sounds like probation was never notified that he had been picked up or was in custody. So they were still under the impression he was in warrant status, and therefore never did an updated PSI until today, when Mr. Brandis showed up for his sentencing hearing after automatically PRing after 14 days.
So
And
what's his bond right now after 14 days?
I believe
Is it PR
I believe
bond?
it would just automatically converted from the no bond to a
Okay.
PR bond, because the sentencing hearing was set out more than 14 days, and the no bond hold was essentially to try and get the PSI done, which unfortunately didn't happen.
So I see how this happened. And yet, Mr. Brandis, this is actually a good time because probation's covering everything right now. Every court officer. You had some fail to appears, and that's why you've had a previous fail to appear out of July 15th, out of October 2025, July 2025, and December of 2025. So I would think that on today's date, Mr. Brandis should probably get an appointment with probation.
That would be my request.
Yeah,
Your
and
Honor.
then and we'll keep you on your bond status, on your PR bond status.
Mr. Flores.
Yeah, I think that's probably the way to go here. And then and then we'll just reset it for sentencing once. I think they can do a PSI probably in about 6 weeks, 4 to 6 weeks.
Yeah, so I would request that the court would consider resetting sentencing, and then I
Yeah.
can bring Mr. Brandis downstairs to get that appointment.
All right, so let's reset the sentencing. Or let's do the 6th, 4th, full, just so probation can catch up.
So let's do July 10th at 10.
July 10th at 10 o'clock. So I think the probation department, if you go see them now, they'll set up an appointment to see you, and then they can do the PSI.
Thank you.
Okay. And then we'll do the sentencing on July 10th at 10 a.m. Anything else for the record in 25-01751, Ms. Fortuna Gill?
Not for the people, Your Honor.
Mr. Harris?
For the defense, Your Honor.
All right, Mr. Brandis, you're all set. Thank you for your appearance.
Good morning once again, everybody. TCF Live, episode 300 on a Super Friday. It's good to have you all here with me. Grandma TCF celebrates 13 months as a channel member this morning. I remember when she came to me and she's like, how do I do this membership thing? And I'm like, you don't have to, Mom. It's fine, you know. But she's like, no, I want to be green like everybody else. So I taught her how, and 13 months later, continues to support me. Thank you. T, 2-month member, says thank you for everything you do. Well, thank you for your support. I very much appreciate you. Let's go back to Judge Anzalone. I think the long pause is over now.
You need to discuss that pre-sentence report with your attorney.
Yes, ma'am.
Okay, don't yawn because you're gonna make me yawn.
Sorry.
Are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes.
All right, do you, Mr. Malaro, wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not to my knowledge, Judge.
All right, so on file number 24-21963FH, the probation department has computed the minimum sentencing guidelines to be 2 to 17. Do you agree with that computation of guidelines? That's on the main 4th degree.
I have no objection to that computation, Judge.
And then on file number 2024-21962FH on the unlawful driving away of a motor vehicle, they computed the guidelines to be 9 to 34. Do you agree with that computation of guidelines?
I have no objection to that computation, Judge.
And then on file number 24-21960FH, they computed the minimum sentencing guidelines to be 10 to 23 months. Do you agree with that computation of guidelines?
I have no objection to that computation, Your Honor.
And last but not least, on file number 24-219.
Sorry, pause. Grandma TCF, $300 super chat. Happy 300, my son. Thanks for all you do at TCF and in my life. Love you, Mom. Thank you, Mom.
59FH, probation department calculated the minimum sentencing guidelines to be 7 to 23 months. Do you agree with that computation guidelines?
I have no objection to that computation, Your Honor.
All right. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Byram?
I would, Judge. Mr. Byram has been, this has been and he's in the middle of this long ordeal. He's clearly has a drug addiction issue. Once he became sober in custody, he's actually a pleasant, well-mannered young man.
Hold on. I'm picking up feedback from something.
She had a girl, she just shut it.
Okay. Go ahead, Mr. Malaro.
I mean, he's certainly old enough to begin the process of getting this behind him, and and he can't plead, youthful indiscretion any longer. But I think he is ready to engage the recovery court program for which he's been approved. And so I would ask the court to file the recommendation. The only question I have, Your Honor, is that there's a recommendation they do a year in jail with the appropriate times of credit. But I'd ask if it's the court's intention to sentence him to that, but allow him to be released to an inpatient program, that be clarified, because it doesn't seem to be clear to me from the recommendation. I think it would be counterproductive to have him do an entire year in county jail and then send him either to an inpatient or outpatient program. I'm fairly certain Mr. Byram, and he would agree, needs to be in some type of residential treatment program so he can get a good, healthy start to the recovery court program. So that would be our request, Your Honor.
Right. So, Ms. Teskey, he is coming into the recovery court program. So would you like to weigh in on that?
Yeah, I have absolutely no objection to anything that Malero just had to say.
All right, Mr. Malaro. All right, Ms. Teskey, another thing is there is discrepancy in the credit, and I know there's like a volume of files. So the front page, well, okay. So on 5-9,
yeah,
is this credit 235 or 217?
You know what? I think I transposed those, Judge. That the second page 3 on the recommendation. Those are the correct numbers, Your Honor.
Got it. Got it. Okay. That's what I wanted to check. Okay. Mr. Byram, is there anything you'd like to say on your own behalf?
No, I'm just ready to get all this stuff done and over with. Feeling too old.
All right. And you understand recovery court is a process, right?
I understand.
Okay. And it's something you're ready to do now.
Yes, ma'am.
Good. All right. In determining the appropriate sentence in these cases, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It is a sentence of the court on file number 2024-21959FH that you will be placed on probation for a period of 3 years and ordered into the recovery court program. I will give you credit for 217 days already served on that file. During your term of probation, you must obey and comply with all the articles of your probation and direction from the probation department. There's a crime victim assessment fee in the amount of $130, $750 in court costs, $68 in state costs, $30 per month supervision fee, $60 if we have to put a tether on you. And as again, you must attend and complete the Lenawee County Recovery Court Program following all rules and recommendations. On file number 24-21960FH, it's recommended, that you will be placed on probation for a period of 3 years into the Lenawee County Recovery Court Program. During your term of probation, you will obey and comply with all the articles of your probation. I will sentence you to 1 year in jail with credit for 235 days, but you may be released to an inpatient recovery program. If you're not eligible for some reason for inpatient, we will revisit it, the jail term. Do you understand that? Okay, on that file, there is $130 crime victim assessment fee, $68 in state costs, On file number 2024-21962 FH, sentence the court to be placed on probation for a period of 3 years. I'll give you credit for time served of 208 days. There's $68 in state costs, $130 crime victim rights fee. On this file, there is restitution in the amount of $16,217.06. So, sir, I will tell you some of your fines and costs can be worked off using community service. Obviously restitution is very important to us. That's a lot of money. So on file number 2024-21963 FH, sentence of the court to be placed on probation for a period of 3 years. In order to enter the Lenawee County Recovery Court program, you must obey and comply with all the articles of your probation. Obviously, you're not to use alcohol, you're not to use any illegal controlled substances. A requirement of the Recovery Court program, because we receive federal funding, is you can't use marijuana either, even though it's legal in the in the state of Michigan. There is credit for 208 days already served, a crime victim assessment fee in the amount of $130 and $68 in state costs. Now, anything else, Ms. Teskey?
Nope, Your Honor, that's it.
Okay, now you do have the right to appeal the sentence, and we're going to get you a copy of your notice of right to appellate review at the jail. They're going to have you initial and date one copy, I'm sorry, for each file to go in our file so that we know that you received a copy of it. If you wish to appeal your sentence, you would fill out the information on the other forms and mail them to the address listed on the form within 42 days. All right?
Yep.
So good luck to you, and I look forward to seeing you in recovery court. All right?
All right, thank you.
Thank you. Okay.
Thank you, Judge.
Thank you, Mr. Millar. I believe that's all you had, right?
I'm sort of tangentially attached to Mr. Lake, so I'll stay for that.
Okay. Okay. We're just waiting for Ms. Underwood. I have Alexia Rowe. Let's take her real quick. So this is file number 2025-22136FH in the matter the people of the state of Michigan versus Alexia Rowe. I have Rhonda Underwood appearing on behalf of Ms. Rowe. Ms. Rowe is currently in custody. You want to move that mic down, Ms. Underwood? I did have an opportunity yesterday to meet with the recovery court team. And so I know yesterday you wanted to discuss bond. And unfortunately, at this point, there have been multiple violations. She is in phase 3, which we find very concerning that she's having these violations in phase 3. So we're not at this point willing, after discussion, I'm not at this point willing to release her on a PR bond. Okay. So I know you entered a plea of not guilty. The biggest problem is also she does not admit to use. And, you know, she's tested positive. We sent it off. We've done everything. And that's a concern. So I can set this for a trial next week if you would like. Thank you. Mr. Coast, will we be able to get someone in by next week sometime?
I believe so, Judge. I'll reach out to Forensic Fluids.
All right, so Ms. Adams, if I can get like an hour towards the end of the week, please.
Okay, and just I wanted to throw out there was another probation violation pre-trial June 10th or trial.
Oh, so we can just set it with the other probation trial and do them both on June 10th.
On Tuesday? What did you say?
So you already scheduled a probation trial on June 10th for her on her other one, violation trial. Why don't we set it for the same day?
Okay, what is June 10th? I'm sorry.
June 10th is a Wednesday. What time was that, Ms. Adams?
It is 1:30 p.m.
1:30 p.m. All right. So I will, Ms. Teskey, okay. She does have a bond. I'm gonna leave the bond as it is, and we'll see you back on June 10 at 1:30 p.m. for a trial. Thank you. Ms. Rowe, you're all set. Okay. All right, so we are still waiting for, okay. So, who are you ready for next? You ready for Mr. Kelly? All right, Mr. Kelly.
Judge,
Yeah.
do you have Cody Kuzno in your waiting room? Okay, he's in residential treatment, so I just wanted to make sure he was there.
Yes, sir.
Thank you.
Mr. Kuzno on the video you're on?
Yes. Let me let him in so he knows we haven't forgotten about him. Becky, I have a bunch of DHS people, but I have a bunch of DHS people. Let me find out. Amanda Jones from Department of Health and Human Services. Can I ask what case you're here on today?
Teague. Judge, there was an email circulating on that. I think they were adjourning, but I think that was set with the referee, but the notice said you.
I have Teague here too, and some Jenny Villegas. I don't know who that is. So do we think I don't have it and it's in front of the referee, or?
Yes, we never had it on your docket.
So it's set in front of a referee. Okay. Abraham. Here's Genesee Villegas.
She is another worker for DHS. She's actually the ongoing worker.
Okay. Miss Adams, do you have a file number by any chance on that?
Let me check the emails. No, it's not an email. I'd have to call downstairs. Hold on.
Miss Jones, do you have a file number on that court file?
I got the case number. That what you
Yeah, let
need?
me have that.
Okay. 60, and then there's 4
No.
zeros.
That wouldn't be it. It would be, okay. All right, so I'm Mr. Teague. Go ahead and unmute your device and start your audio. And Miss Villegas, I think there's some confusion today. I don't have this scheduled on my docket. And I think it's in front of, you said the referee, Miss Adams?
That's what we were assuming. I did get an email from attorney Greg Iddings, and they were looking to adjourn it, and that's all I knew.
So Mr. Teague, do you have an attorney?
No, I don't.
So I apologize. I do not have this in front of me. I'm assuming it might be in front of the referee down at the front of the court, or in front of, would it be the front of Ms. Frost or the referee in probate?
Your Honor, our notice of hearing says you.
I get it.
So I guess we didn't know that it was in front of the referee or anything. So
I don't know where it is. Our file system doesn't have access to that system. I would probably reach out to Mr. Iddings. Mr. Teague, I'm gonna release you.
Okay.
Because I can't tell you where to go. So obviously I'll give you a note excusing you if I have to.
Okay. Thank you.
All right, thank you. Okay, hold on, let me take a breath. All right, Mr. Cruz, now just bear with us for a moment.
That's okay, Judge.
Well, it's not hantavirus, at least, Ms. Underwood. So, okay, so we are now with Mr. Kelly. I'm gonna put this on the side. This is in the file number 2023-12628 FH in the matter, nope, I'm gonna sneeze, hold on, I'll be right back.
So for those of you who haven't been following along, Judge has been sick for a few weeks now, and she said it was getting better, and then yesterday she said it was getting worse again. So hopefully she gets better soon. We'll wait for her to return to the bench and come back later, but let's go back up to Lansing, Michigan. This time Judge Buchanan. We'll see what she's got going on this morning.
Which case is the version of situation? Do we need that file?
I have it here.
Okay.
Well, what I have is, I didn't write this version, license forgery, alteration, unlicensed dog, and then of course the assault and dangerous weapon.
The case number for that one is 24-3075.
ST. And that is operating license forgery, alteration, false ID.
That's 03075 ST. Yes.
Mr. Goodrich, is there a license consequence to that one? It's a 257 statute. No,
Yes, but did you catch the driver's license?
yeah, at physical, I mean,
Your sister's.
no, I just said my.
You just said your sister's.
Correct. Abstract 90-day suspension.
I mean, is it charge for it? Because I mean, it's given.
I mean,
We can
given
amend
a
the
false
charge if
name.
we need to amend the charge. Yeah, if you just do the false name, because it's. She was a driver and gave a false name. Oh, that's effectively. It's a false name. Do you know the prison penalties for furnishing false name, whatever it is? Usually that's always the city of Lansing charges. Well,
Can't put it under city ordinance.
right, I know, I'm just saying that's what we normally have.
The clerk's heads will explode.
Yes, and we had a mass email go out saying that you cannot do, city ordinances because I don't look at city.
That might be a thing.
Whether it's a thing or not, I will get in trouble if I do it. So, what I do for not get in trouble. We.
Okay, friends, I don't normally abandon mid-case, but to be honest, they haven't even started their case yet because they're still trying to figure out how to charge things from the sound of it. You'd think they'd have that sorted before going in front of the judge, but whatever. Judge Buchanan's court is weird. Often it's very efficient. Other times it's all over the place. Let's go to Florida. Judge Grover continuing to sit in for Wade Mercer.
Mr. Avila, did you see the video advising you of your rights?
I'm sorry?
Did you see the video advising you of your rights?
Yes.
Okay. You are charged with DUI. Anything from the attorneys?
No, Your Honor.
No, Your Honor.
Where do you live, Mr. Avila?
I live on 4484 Franklin Street, Mariana.
Okay. How long have you lived in Jackson County?
About 3 years now, 4 years.
Okay. Where do you work?
I work at Bonifay McDonald's. I used to work
Okay.
at the Mariana McDonald's.
Very well. So here's my question. If I release you, first off, you have to show up for your court date. Is that something you can do?
Yes, I can.
Also, you're going to be subject to both a mandatory and a random alcohol test. So,
yes,
so
sir.
listen to the things I'm about to say. You will be placed on the Jackson County Conditional Release Program. You must show up, obviously, for your court date. You will receive paper notice with your date and time. You cannot drive unless you have a valid license. Do keep in mind, in all likelihood, your license is going to be suspended. It's your responsibility to monitor the status of your license, and you can do that through the Department of Motor Vehicles. But
Yes, sir.
I'm pretty much 100% certain that your license will be suspended. You're required to submit to a mandatory alcohol test every Monday between 9 and 3 Central Time. That time may be adjusted by the conditional release officer, but I think this time will work. Between 9 and 3 Central Standard Time every Monday. If Monday is a holiday or if the office is closed for whatever reason, it would revert to the following day, obviously, which is Tuesday.
Okay.
You're also subject to a random breath sample or random alcohol test at any time as requested by the conditional release officer. You cannot violate the law. There is a monthly supervision fee for the conditional release program. I believe it's $50, but if it's not, it's something very close to that, and you will be advised of that. You do not have to pay that today. Do you understand all of the conditions?
Yes, sir. I do.
Also, I would request that the officer not initiate a release until noon today. In consideration of the time of the arrest and the blood alcohol level as tested, I want to make sure that all the alcohol is out of his system. So it's a conditional release, but not until noon or later today. So our next case is Precious Thornton. Oh, sir, one more thing. You do need to report, Mr. Avila, you do need to report to the conditional release office as directed by the jailer today, okay? That'll probably be, well, maybe today or Monday, but they'll advise you at the jail when and where to report for the conditional release program. So next we have Precious Thornton. Ms. Thornton, did you see the video advising you of your rights?
Yes.
You're here on a violation of probation. You are held without bond. You'll receive paper notice of your court date, and you will be transported to the court date. Do you understand?
Yes, sir.
Okay. Next, we have James McClain.
Okay.
Mr. McClain, did you see the video advising you of your rights?
Yes, sir.
You are charged with possession of methamphetamine, tampering with physical evidence, and possession of drug paraphernalia. Anything from the attorneys?
No, Your Honor.
We just request to be subject to random UAs.
Very well. So, Mr. McClain, I'm going to set your bond on the possession of methamphetamine at $1,500, tampering with physical evidence at $1,500, possession of drug paraphernalia at $500. Your total bond is $3,500. If you make the bond show up for your court date, you'll receive paper notice with date and time. You are subject to a random drug test. Do you understand?
Yes, sir.
Your Honor,
Next,
that
we
was
have Loretta.
3,500 total.
That's correct.
Thank you.
Next, we have Loretta Swearingen.
Hey, Your Honor. Hey, Judge,
Yes,
can I
sir.
say something? Hey, look.
Sure.
No, I ain't. Hey, look, I just had to say this, and it ain't nothing like, Brandon Philman, I love you. I know you're watching this, baby, and I'm truly sorry.
That's all right. Next, we have Loretta Swearingen.
What's this swag, huh?
Ms. Swearingen, did you see the video advising you of your right?
Yes, sir.
You are here on an out-of-county warrant for Washington County. They have you held on a VOP. They will come pick you up. That shouldn't take very long. They're close by. When you get there, they will first appear you again. They will address bond, although it's quite possible they'll continue to hold you since it's a violation of probation. And they will give you notice for your court date. Do you understand?
Yes, sir.
Next, we have Miss Bailey, and could you, I'm having difficulty reading the first name. Could someone tell me that first name?
It's Kool-Aid.
Kool-Aid, thank you. Miss Bailey, did you see the video advising you of your right?
Yes, sir.
You're here on a violation of probation. You are held without bond. You'll receive paper notice of your court date, and you will be transported to the court date. Do you understand?
Yes, sir.
Okay. Next, we have Manuel Oliva.
Your Honor, Mr. McDaniel, the typical public defender for Jackson County First Appearances, has submitted a motion on this case. I don't know if Mr. Mitchell wants to be heard at this time, but I just want to make sure that the court was aware.
Thank you. And I did notice the email, and I do appreciate that. I am aware of it, and I did have time to review it, and we'll address that in a moment. Mr. Oliva, did you see the video advising you of your rights?
Good morning, Your Honor. Yes, I have.
Okay, now you're charged with driving without a valid license. There is a motion pending, and the first question I have is to the state, and do you agree or disagree with the motion, with the points made in the motion?
I stipulate to the motion, Your Honor, and as we speak, I'm actually working on a no information right now, given the fact that this case is pretty much 10 years old and, you know, there hasn't been any procedural activity for over 5 years in this matter. So the state announces an official dismissal of the charge, and we'll be filing the no information in a few moments.
Okay, thank you, Mr. Mitchell. Mr. Oliva, the state is agreeing with the motion, with the points that are made, which essentially means that your case is going to be dismissed. It will be dismissed. You will be, and if you have no other things holding you in custody, you will be released, and that will conclude the matter. Do you understand?
Absolutely, Your Honor. I want to say thank you for allowing me to have me in your court today. I know that I have violated the sanctity of this county. I am not from this county, and it's unfortunate that, you know, that I had to come across and meet you guys under these circumstances. I just wanted to say thank you for taking the time to having me here today.
Okay, good luck to you.
Thank you, sir.
Next, we have Garrett King. Mr. King, did you see the video advising you? Good morning. Did you see the video advising you of your rights?
Yes, sir.
Okay, you are charged with trespass and battery. Anything from the attorneys?
No, Your Honor.
No, Your Honor.
Okay. So in this case, independently with these charges, if I addressed them, if there was just one, if there was a trespass or a battery, I would consider a release in your case. However, according to the affidavit, there's probable cause that you committed a battery while trespassing on the property. And that makes it a little different from my perspective. So as a result, I'm going to set monetary bonds, and I'm going to set those bonds at $2,500 per count for a total of $5,000. If you make the bond, you must show up for your court date. You'll receive paper notice with date and time. You cannot have contact in any form or fashion with Melina King or her residence. If you violate the no contact order, the most likely outcome would be that a warrant would be issued for your arrest, and you would be held without bond, and you could be in jail for weeks or months. So if you would like to remain free, assuming you post the bond, you cannot have contact with Melina King or her residence. Do you understand?
Yes, Your Honor.
You will also be subject to a random alcohol test. And once again, it is a total bond of $5,000. If you make the bond, you must show up for your court date. You will receive paper notice with date and time. If you do not make the bond, you will be transported to the court date. And for clarification on contact, it's considered very broadly. So whatever you think may be contact, it almost certainly will be contact. No personal, no email, no third party. You can't send flowers, you can't wave at her. If you pass her on the highway, you can't post on social media about her or information that you expect she will see pertaining to anything between the two of you. So just keep those things in mind. Do you understand?
I understand.
Okay. So next we have Jonathan Joyner. Mr. Joyner, did you see the video advising you of your rights?
Yes, sir.
Okay, so you were charged with 6 counts of criminal use of a personal identification and organized scheme. Yes.
Those are the ones he did yesterday. The only one, we just got a new charge for a hold for Okaloosa County. These faxes over.
Thank you. Thank you. Okay, I thought we had first appeared those yesterday. I appreciate your input. So whatever you had, he received bonds on those cases yesterday, I believe, but we do have the hold for Okaloosa. With that's accurate, sir?
Yes, sir.
Okay, thank you. So, so Mr. Joyner, actually, the cases I originally called out, those were from yesterday. You're back today simply on a hold for Okaloosa County. Okay, so
Yes,
they
sir.
will come pick you up most likely when your cases are resolved in Jackson County. And of course, when you get to Okaloosa County, they'll first appear you again, go over your charges, address bond, and give you notice for your court date. Do you understand?
Yes, sir.
Your Honor.
Okay. Yes.
This is the defendant that I requested be brought back next week to see Judge Mercer, even though it was a felony case, because he was in a rehab program. Given the fact that he now has a hold for Okaloosa County, I see no need for him to be brought back next week. The bonds are reasonable bonds. There's sufficient probable cause exists. The only reason for my request was because of that rehab program, but it's not going to matter with the Okaloosa hold.
Anything from the state?
No, Your Honor, I'm in agreement with Ms. Parrish.
Okay, and that makes absolute perfect sense. So, officer, we can remove him from the reappear on Monday. He's held no matter what.
Yes, sir. Thank you very much.
Anything else? Thank you. Anything else?
What are
Okay,
my
thank
charges
you.
in Okaloosa?
I'll let you know what your charges are.
And just like that, he's done, I guess. Good morning once again, everybody. TCF Live, episode 300 on this Super Friday. Austin, thank you for putting all of that info in the chat regarding what the defendants are advised of before they first appear there in Florida. And Tim, thank you for gifting 5 more memberships. Very much appreciate that, sir. Let's go back to Lenawee County Judge Anzalone. She is back on the bench.
Kelly says the date and time set for a sentencing on a probation violation. I run Underwood appearing on behalf of Mr. Kelly. So, Mr. Kelly, have you had an opportunity to read and review the probation violation report?
Yes, sir.
All right, you got to speak up for me, okay? Attorneys are naturally allowed. defendants usually are not. So you've had an opportunity to discuss this with Ms. Underwood.
Yes, Your Honor.
And are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, Your Honor.
Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in this?
Well, a couple of things, Your Honor.
Okay.
First of all, I would like to point out just for
And once again, we are forced to pause, and I'm happy to do it. Lindsay gifts 50 memberships. You guys are just amazing. The generosity that all of you show to me and to this community. Yeah. Thank you, Lindsay. Thank you very much.
the record that I believe Mr. Kelly took the plea pro per, Your Honor, and I was assigned for sentencing in this matter. So I reviewed it this morning with Mr. Kelly, and there are some things that he has a problem with. First of all, the notations, I'm sorry, as to opiates and illegal drugs, Your Honor. He would strenuously object to that because Mr. Kelly has been in the hospital quite a bit. He's obviously prescribed drugs in the hospital. And I believe he's given I believe he's given the probation department a list of those drugs, and some of them may well be opiates or something, but I don't know. I don't think we can, we can't say he's been using illegal drugs, right? Or inferring that. Mr. Kelly pled guilty, as I understand it, to an alcohol violation and the other violations, which are all technical violations. In addition, Mr. Kelly has paid off all his fines and costs and has a good job at highlights. This is his first violation. The probation department, Ms. Holly, has recommended prison. I would hope with this being a first violation and his and being technical, most especially, and the fact that he's paid off all his fines and costs, seems to be getting right and is working, gainfully employed, which is what we want from our probationers. I would hope that prison does not enter the calculation here. That's what I'm going to say.
Okay. All right. Mr. Kelly, is there anything you'd like to say on your own behalf?
Just the only violation that I had was the alcohol. Like the drugs that were listed, I brought in a note, like, because I also missed dates to do drops. And I brought in notes saying like I was in the hospital at that time. And I also brought in notes like giving a list of all the drugs that they gave me. So.
Okay.
Judge, I just want to make one point on that keeps getting brought up. I just want to make a point that he tested positive for opiates, cocaine, and morphine. I don't think cocaine is part of those medications here.
I don't know how it does.
Oh, no, I'm sorry. There's no big thing. Okay. Where do I? So this is like, this is the violation back from September of last year, right?
Correct.
Okay. Okay, anything else?
Nothing else, Your Honor.
So Mr. Kelly, yeah.
Probation would be continued.
All right, so Mr. Kelly, what's going on? Are you on probation anywhere else now? You're maxed out in Jackson.
Yes.
Maxed out in Hillsdale. All right. Mr. Kelly, I mean, as much as we want to minimize it, you still got these new cases in other counties. You have a domestic violence with a partner. You know, obviously your life, you are still having these struggles. So I'm just saying, these aren't things that most people have happen in their lives, right? So I hope that you're counseling, doing whatever it is you need to do. It's sentence of the court that I'm going to, he's paid everything off, right, Ms. Holly?
He was owing a little bit on supervision fees and may have paid that off, but other than that, yes.
All right, and he's had no new offenses since his violation in September.
Nothing come through the courts.
All right, sentence of the court, your probation will be continued. You will receive credit for any time served you have on this. Mr. Kelly, your guidelines require you to do a prison term on one of these offenses. So, you know, you need to, obviously, how long has he been on probation? 2 years now?
His discharge date is December 27.
All right, so hopefully there's no further issues and you'll discharge in December, all right? All right. Now you do have a right to appeal the sentence. There's 2 files. My bailiff's gonna hand down to you your notice of right to appellate review. You're gonna initial and date the top copy for each file for our records. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right?
Judge, can we have the drug testing continued?
Yes,
Thank you.
I mean, that's part of his probation term, right?
Right, but he's doing it through a place out of Jackson.
Ever Health, yep, that's fine.
Your Honor.
Who's now?
Why don't you push no first or Mr. Caldwell?
Well, he's in a captive. I've got him in custody, so he's not going anywhere, but Mr. Kuzno, we could lose him. Okay. All right, Mr. Kuzno, she's gonna go get on Zoom so we can take care of you.
Thank you, Your Honor.
No.
Tot, thank you for gifting 5 memberships. I very much appreciate you as well. A relative newcomer here to TCF, but very much a part of the family and could not imagine you not being here with us every morning. So thank you so much for the time and the love and the generosity that you show to all of us. I very much appreciate it. Let's go to Ohio. It's been a while since we've seen him. Judge Collada.
Good morning, Your Honor. We are here in case 26 CR 386, State of Ohio versus Laura M. Kovach. Present in court is the defendant, who is accompanied by her attorney, Mr. Samuel Smith. We are here today for a change of plea hearing. It is the state's understanding that the defendant intends to withdraw her previously entered plea of not guilty and enter a plea of guilty to a lesser included offense of count 1, domestic violence, a felony of the 4th degree. There is no agreement with regard to sentencing, and the state would request a pre-sentence investigation report. Thank you, Your Honor. What's the reason for the reduction? For purposes of the plea agreement, the state would agree that there was 1 prior conviction for domestic violence.
I guess what's the reason behind the state agreeing to a reduction?
Just based on the facts and circumstances of the case.
Okay. Mr. Smith, does that all sound accurate?
Yes, Your Honor, that is accurate.
Ms. Kovach, were you able to hear what the prosecutor just had to say regarding what she believes your intentions are here this morning?
Yes, sir.
She indicated to the court she believes it's your desire to withdraw your previous entered plea of not guilty and plead guilty to a lesser included offense of domestic violence, a felony of the 4th degree. We would then defer sentencing to get some reports completed, come back on a future day where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do this morning?
Yes, sir.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I am going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
All right,
All right, let's get started then. How old are you?
47 years old.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came to court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No, just medication at the jail.
Well, what prescribed medication have you taken in the last 48 hours?
Depakote, Boost Bar, and Gedon. Propalo.
Hang on, Depakote, Buspar, what else?
Gedon. Propalo.
What was the last one?
Propanol. It's a heart and blood pressure medicine. What else? Prilosec. Synthroid. And I believe there's one more in the morning for like medical. Shoot.
What's the last one for? You don't remember?
The Prilosec, the Synthroid.
I know what those are for.
There was another one, the Propanol. Buspar, Gedon. I think that's it right now. And then, yeah.
All right, well, I wrote on this form, it says, I'm not under the influence of well, let me ask you this question first. Do any of these medications that you've just taken within the last couple of days, do they affect your ability to understand or appreciate where you are, what's
No.
going on around you, or negatively impact you in any way?
No.
Okay. Well, in the form that you looked at previously, it says, I'm not under the influence of drugs or alcohol, and I have not taken any drugs or alcohol in a 48-hour period preceding this hearing. And I added, except for Depakote, Buspar, Gedon, heart and blood pressure medication, Prilosec, and Synthroid.
Correct.
Does that sound accurate?
Oh, that's accurate. I mean, sorry.
All right. Now, did you receive, well, I know you did receive a copy of this indictment. You got it back about, a couple months ago. No, that was when you were bound over. You got it about a month ago, a little over a month ago.
Yeah.
That's the document that sets forth the charge. Do you remember getting that?
Yes.
And you had a chance to look that over at some point?
Yes.
Now, in that indictment, you're charged with one count, and what's alleged here in count one is on or about March 17, 2026, in East Lake County, Ohio, that you did knowingly cause or attempt to cause physical harm to Michael Agapi, a family or household member. It's further alleged you have previously been convicted or pled guilty to 2 or more offenses of domestic violence, that being Lake County Court of Common Pleas on February 18, 2025, the Lake County Court of Common Pleas on July 10, 2024, the Mentor Municipal Court on August 10, 2022, and the Willoughby Municipal Court on June 27, 2007. That conduct with those prior convictions constitutes the offense of domestic violence. It's a felony of the 3rd degree. Do you understand what you're charged with? What you're charged with in this count? You're not pleading guilty to that charge, but that's what you're charged with. You understand that? Any questions about it?
No.
Now, for purposes of the plea today, the state has agreed to delete 3 of those convictions that are listed in that second paragraph, so there'll only be 1 alleged prior conviction. And the difference with having only 1 prior conviction versus 2 or more is that it reduces it from a felony of the 3rd degree to a felony of the 4th degree, which is less serious. There's a big difference between a felony of the 3rd and 4th degree. But that's what you'd be pleading guilty to. You'd only be admitting to having 1 prior conviction, which would make it a felony of the 4th degree, for purposes of this plea. You understand that? Your client's trying to talk to you.
Okay, now I understand. Okay, sorry.
You have any questions for me about it?
No.
Okay. So for purposes of the plea today, the state has agreed to allege that you have previously been convicted of 1 prior conviction.
Okay.
And again, that makes domestic violence a felony of the 4th degree, and it reduces it from a felony of the 3rd degree, which is what you're charged with.
Okay.
You understand that?
Yes.
Any questions?
No.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you are giving up by pleading guilty. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jury would consider and weigh all that evidence, and the jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be unanimous. Unanimous means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to have a trial?
Yes.
Now, if you had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence stays with you and remains with you until the state, if at all, is ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes.
Now, when we speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. What it actually means, it's the amount of the evidence and the quality of all that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of the charge beyond any reasonable doubt before you could ever be found guilty of this charge at a trial. Do you understand that?
Yes.
Do you understand that by pleading guilty, you're giving up your right to have a trial in this case?
Yes.
And make the state prove you guilty beyond a reasonable doubt? That's what happened. You're giving up your right to make the state prove you guilty beyond a reasonable doubt at a trial by pleading guilty. You understand that?
I'm going to plead guilty.
But you understand that's what you're giving up?
Yes, yes.
Okay.
Sorry.
Now, in order to try to prove you guilty, if we were going to have a trial, the state would bring witnesses into the courtroom to testify for the state, and they would answer questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. So he could ask him anything he wanted to, but within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not obligated or required to do that. But you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. That order we call a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if there was anyone out there that wasn't willing to come in voluntarily on their own and you wanted to have them testify. You understand that?
Yes.
You understand you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we went to trial and you were found guilty of this charge, you would have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding that I'll enter if I accept your plea, as well as any other issues that you could have raised or brought to my attention up to this time. You understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand that your guilty plea is a complete admission of guilt? That means you're going to be admitting to the facts being alleged here, We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that guilty plea is that you will be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 4th degree. It's the reduced charge. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. You understand that?
Yes.
Now, obviously, I'm aware that you're on probation to this court and 2 other cases. Are you on probation anywhere else?
No, sir.
Do you have any other charges pending against you anywhere?
No.
And I do need to advise you, and I know you're aware of it already, but you're on probation to this court in 2 other cases. So if you commit a new crime while you're on probation, a motion to terminate your probation or community control sanctions could be filed. In fact, it has been filed in both of those cases, and those motions are pending based on the outcome of this case. But there can be consequences in those other 2 cases as a result of pleading guilty here and being convicted of a new offense that you committed while you're on probation to this court in those other 2 cases. You understand that? That means you're on probation in those other 2 cases, and you were advised when you were put on probation that if you ever violated the conditions of your probation, your community control sanctions could be terminated, and you could be sent to prison for those cases for violating your probation. The 1 case, the 23 case, you face up to 18 months in prison. The 24 case, you face up to 3 years in prison. So if you're convicted in this case, which you would be if you pled guilty and I accepted your plea, we're going to have hearings on the other case to see if your probation should be terminated and what should happen there. So there will be consequences in those other cases as a result of pleading guilty here. Do you understand that?
Yes.
You have questions for me about that?
I don't think so. No.
And those consequences, I mean, ultimately could be you go to prison in those other 2 cases. If that's what I determine. That's not automatic. We'll have hearings on those cases, and we'll come back for sentencing on all 3 cases, the 2 older cases, and then this one will be sentenced all at the same time.
Oh, at the same time?
Yeah.
On the 6th or?
Whenever that is, I don't know what the date is, but we'll come back and we'll have the sentencing on all 3 cases at the same time.
Okay.
But I want to make sure you understand that as a result of pleading guilty here today, that could result in consequences in those other cases. You understand that?
Yes.
Now, if a prison sentence is imposed in this case, and it's imposed in the other cases, as the judge, I had the discretion to run those prison terms either concurrent or consecutive. Concurrent means you serve those prison terms together all at the same time, whereas consecutive means you'd serve whatever sentences were consecutive one after the other. You'd finish the prison term on one case, then serve the next, and then serve the next. You understand that?
Yes.
So in this particular case, your maximum prison sentence you face is 18 months. With all 3 cases, you're facing a maximum prison term of 72 months or 6 years. Do you understand that?
Yes.
If a prison term is imposed in this case upon your release from prison, you could be placed on what is called post-release control, sometimes called parole. That's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you were on post-release control at any point for this case, never violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half, whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence, there are other sanctions that could be ordered. You could be fined in this case up to $5,000. You could be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable in this case. Do you understand that?
Yes.
You can also order you to pay restitution if that's applicable. I don't know if it is, but for any economic loss any victim may have suffered as a result of the conduct. Do you understand that?
Yes.
Sorry?
I see.
You have to speak up.
Oh, yes.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison is not mandatory or required with this charge. You are eligible for probation, what's called community control sanctions. Do you understand that?
Yes.
Do you understand just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're requesting. I'm going to look at all the information and circumstances, and I'll make the decision I think is the right thing to do. Do you understand that?
Yes, sir.
If you are put on probation, it could be for up to 5 years, and as the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions can be in order that you serve a term in the Lake County Jail of up to 6 months, the condition of probation. You understand that?
Yes, sir.
Further, if you're on probation or community control and you're violating any of the conditions of your community control, we would have a hearing in the court here for this case to determine whether you're a probation violator. If it was determined that you were, I could extend your probation up to 5 years, I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison then, again, it could be 6 to 18 months in prison, which could be consecutive to any other sentence you may be serving at that time or that you're being sentenced to at that time. You understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right. Well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer, have him review the report with you, discuss the issues, answer whatever questions you have?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the guilty plea freely and voluntarily?
Yes.
All right, then, do you have any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to?
No, sir.
You need to speak up.
No, sir.
Do you need any more time to talk to your lawyer before we go forward with your actual plea?
No.
Well, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show if we had a trial. I want you to listen to her and what she says, because I have some questions for you about that, all right?
Okay.
Ms. Emmeline?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on March 17th, 2026, in the city of Eastlake, Lake County, Ohio, the defendant did knowingly cause or attempt to cause physical harm to a family or household member at the time, Michael Agapi, causing a laceration above his right eye and scratches on his body. And for purposes of the plea agreement, the state has agreed that the violent conviction out of this court, Lake Court, case number 24 CR 1277, dated February 18th, 2025. Thank you.
Thank you. Ms. Kovach, were you able to hear what the prosecutor had to say regarding what she believes the facts would show if we had a trial?
Yes, sir.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir.
Very well. Then regarding lesser included offense of count 1 being domestic violence, a felony of the 4th degree, what is your plea to that count?
Guilty, sir.
I have with me right now a 4-page document called a written plea of guilty and judgment entry, which sets forth everything I've just discussed with you. Before I can accept your plea, I need to make sure you understand the document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Correct.
Mr. Smith, is that accurate? Did you review this with Ms. Kovach, read it over to her, answer all her questions?
Yes, I did.
Did she indicate an understanding of it to you when you went over with her?
Yes, you did.
Is that correct, Ms. Kovach?
Yes.
So you understand what that document says?
Yes.
Do you have any questions for me about it?
No, sir.
It also appears you signed it. Did you sign it?
Yes.
And Mr. Smith, you witnessed that?
Yes, I did.
Ms. Himmeline, you as well?
Yes, I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, and made a knowing, intelligent, voluntary waiver of all those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of lesser included offense of count 1 being domestic violence, felony of the 4th degree in violation of 2919.25. I'm going to defer sentencing, order an updated pre-sentence report, continue bond, and victim impact statement as well. Did you say we have a sentencing date?
Yes, sir.
When is it?
She had July 6th?
Well,
Yeah, July 6th after 3:30.
stick around. Yeah, that's too far.
Okay.
Stick around for a minute. All I'm doing is an updated report, and it's so. All right. Anything else for the record at this time, Ms. Himmeline?
No, Your Honor, thank you.
Mr. Smith?
No, Your Honor.
Thank you.
All rise.
Now solidly, there we go. Speak, Dan. Now solidly in hour 2 of TCF Live. Happy Friday, everybody. Good to have you all here with me. Let's go back to Judge Anzalone, new contestant there.
This is in the matter of the people of the state of Michigan versus Richard Lewis Lake Jr. File number 2026-22571FH. This is a Judge Michael R. Olsaver file. Mr. Lake, we are here today on a motion affidavit and bench warrant, which alleges that you have violated your bond conditions and that you failed to get fitted with a GPS tether and SRAM device by May 21 of 2026 as directed by the court. Now, Judge Olsaver signed this warrant and set no bond in this matter because you were maybe released and didn't show up. So your current charges are 2 counts of R&O. And it's my understanding, Mr. Lake, your attorney was here earlier, but he's in between court in another county. He stated that you are also evidently possibly being arraigned on new charges down in the district court. Do you have any information on that, Mr. Gumto?
Judge, I could speak to that.
Okay.
He does have new charges that were filed, and yeah, I imagine, yeah, now that he's in custody, he'll probably get arraigned on those. We were going to try to turn him in the other day, but I think things got miscommunicated. But he has been in contact with Mr. Amadeo and myself, so.
So, Mr. Lake, one of the things I spoke to Mr. Amadeo about was that you have a hearing scheduled in front of Judge Olsaver on June 9 at 3:30 p.m. So I'm going to set, Mr. Malaro, I assume Mr. Amadeo would want him to enter a plea of not guilty today?
Yes, we would be, I have a case with Mr. Lake as well, so what I would be doing is advising him to plead not guilty or stand mute so that a not guilty plea gets entered. And if this is set for the, you said the 9th, Judge, which is
June
a
9th
Tuesday?
at 3:30, he has a pretrial bond hearing.
I would ask the court set this for that time as well.
All right, so, Mr. Lake, I'm gonna enter a plea of not guilty today, okay? And then I'm going to set this over to your next hearing date on June 9 at 3:30, okay?
Yes, ma'am.
All right, we'll see you back on that day. Thank you.
Thank you, Judge.
Thank you.
Judge,
Yes.
if I may, if Mr. Amadeo pops back in, could you put him and I into a breakout so we can discuss what we're doing with Mr. Lake?
I can do that.
Thank you.
No.
I'll hang
I
around.
can do that. Okay.
All right, we'll keep an eye on her courtroom. It is a spotty Friday out in Courtlandia, as is often the case. But let's do this. Let's go back to Lansing, but this time Judge Christian Simmons.
Mr. Cadet is scheduled today for a examination for weapons carrying concealed. My understanding is there's going to be a waiver. Is that accurate?
Yes, that's the people's understanding.
Has there been an offer?
No, the negotiations will continue.
Okay, Mr. Cadet, you understand your right to have a preliminary examination? You understand the purpose of the exam? Do you have the right to require that the prosecution establish at the district court that they have sufficient probable cause that a felony was actually committed, and then probable cause sufficient to charge you as the person who committed the felony? You understand that?
Yes.
And you wish to unconditionally waive your right to have that exam? Why are you looking at him? You don't know what you want to do?
I'm not really familiar with court terms and words.
Well, you don't have to be familiar with court terms and words, but if you came in here to waive, you got to be familiar with what you're doing right now. No?
Yeah.
You understood what I said, which is that you have the right to hold this examination. You do not have to waive it. You understand that?
Yes, I do.
Okay. And my question to you is that, do you want to waive it? Because it's not about what your attorney wants to do, or even if he advises you that he thinks it's in your best interest to waive, you still don't have to waive because of that. It's what you want to do because it's your right. Do you understand that?
Yes, ma'am.
How do you want to proceed?
Yes, I do want to waive this case.
Okay, no one's promising you anything to waive your right to exam, correct?
Yes, correct.
Any threats being made to you to get you to waive your exam?
No.
Okay. Your bind over date is June 10th. That's the date the circuit court's receiving this file, not a date that you need to appear in the circuit court, okay? Do you understand that? Yes. Your next court date will be set after they receive the file. It's going to be for a pre-trial, and your attorney will be made aware, okay? So you stay in contact with Mr. Green. Do you have any questions at this time, sir?
No.
The bond was set at 1,000 personal recognizance that will continue. Any additional matters for the record?
Nothing wrong with the people, Your Honor.
Nothing further to defend, Your Honor.
You're all set.
Thank you.
Yes.
Have a good weekend, everyone.
Same to you.
Okay, quick question.
You may. Versus Lincoln Child, 26-01248. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Good morning, Your Honor. Dustin Coons for Lincoln Child, who's here to my right.
Mr. Child was scheduled to have an examination today on a felonious assault, felony firearm, domestic violence, second. There was a second offense notice attached. And there's going to be an unconditional waiver, is that correct?
That's the people's understanding, Your Honor.
Has there been an offer at this time?
There is no exact offer. Again, I believe spoken with defense counsel about the group not possession of a firearm, so we intend to honor that agreement.
Approach. Justin.
Ultimately, we're gonna circuit court resolution.
That's all correct, Your Honor. I would briefly add that people did extend an offer for this to be resolved in district court, a misdemeanor offer. My client is.
There was an offer.
But I think because of the waiver, there is not an offer. There's not a further offer.
No, there is an offer. He's rejecting it.
Yes.
That
So
needs to be,
there's no-
that definitely needs to be placed on the record.
There was a district court offer of a DV, domestic violence second, and brandishing. The main count 1 to the domestic violence second, a main count 2 to brandishing, and we would dismiss count 3 with the offer.
Okay, Mr. Childs, how are you?
Doing well. How are you?
I'm doing okay. Okay, you understand that you're being charged with felonies in this complaint, correct?
Yes, Your Honor.
Count 1, a maximum penalty 4 years and $2,000 in fines. Count 2, maximum penalty 2 years consecutively with and preceding any term of imprisonment imposed for a felony or attempted felony, and a mandatory forfeiture of the weapon or device. And then count 3 as charged is going to be 1 year, $1,000. You understand that?
Yes, Your Honor.
And did you understand the offer that was extended to you at the district court?
Yes, Your Honor.
And do you understand the purpose of a preliminary examination?
Yes, Your Honor.
So you have the right to require that the prosecution establish that they have sufficient probable cause that the felonies you're being charged with were committed, and then sufficient probable cause to charge you with those felonies. You understand that? Okay, so you wish to first reject the misdemeanor offer and then waive the preliminary examination, correct?
Yes, Your Honor.
Okay, and no one's forcing you to do that. You're doing that on your own, correct?
Yes.
No one's promising you any reward or better a plea offer at the circuit court, correct?
No.
You actually understand it's not likely you'll get a better offer at the circuit court, correct?
Yes, Your Honor.
Okay, so you want to go to trial?
Yes, Your Honor.
Okay. Your bind over date's gonna be June 2nd. That's the date the circuit court's gonna receive the felony file, not a date you're going to be required to appear in the circuit court. Do you understand that?
Yes, Your Honor.
Your next court date will then be set after that, and Mr. Coop will be made aware of that date, so you'll stay in contact with him. Okay? Do you have any questions at this time?
No, ma'am.
Bond was set at 1,500 cash surety. I'm trying to understand the note right there, but I don't get it. Okay, there is GPS tether. You're on tether, sir?
Yes, ma'am.
Okay, and you're not to be within 2,500 feet of the protected party, correct?
Yes, ma'am.
And it says victim notification if possible. Any additional, that will continue. Any additional matters for the record?
Nothing wrong with people, Your Honor. No, thank you, Your Honor.
You're all set. Thank you. Set up from upstairs. Flores. And he's bringing up Jones, I think, for a plea. Oh, is, Juwan Edwards here? Oh, we can do that one. This is State of Michigan versus Juwan Edwards, 26-01242. Appearances, please.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people.
And thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Mr. Edwards. He stands present to my right.
Okay, Mr. Edwards was here for preliminary examination today. Count 1 is an assault with intent to do great bodily harm less than murder or by strangulation, and count 2, domestic violence, third or subsequent offense notice. And my understanding is that there's going to be an unconditional waiver today.
That is the people's understanding.
My understanding as well, Your Honor.
Has there been an offer at this time?
There was a district court offer of aggravated domestic violence. That was rejected. There is no circuit court offer.
That is correct, Your Honor. I would just further add from my discussions with Mr. Smith, he would have also been amenable to allowing Mr. Edwards to plead to a DV second, which has the same penalty. And my understanding is that Mr. Edwards wishes to reject that offer and proceed to circuit court.
Okay, very good. Okay, Mr. Edwards, how are you?
How are you this morning?
I'm doing all right. Okay, so you understand the purpose of the preliminary examination? You also understand the offer or offers that was extended to you?
Yes.
Okay, and you wish to reject the offer and also waive your right to have a preliminary examination.
Yes.
I should also indicate that although he is also being charged as a DV third, there has been an habitual offender fourth offense notice. So that would also enhance your sentence if convicted. You understand that?
Yes.
Okay. Okay, and so you wish to waive your right to have the prosecution establish if they have sufficient probable cause that a felony was committed and probable cause sufficient to charge you as the person who committed the felony? Okay, and no one's promising you anything to get you to do that, correct?
No.
No one's threatening you to do that.
No.
Date is going to be June 10th. That's the date that the circuit courts receive file, not a date that you need to appear in court, okay?
Yes.
Your next court date will be a free trial. Your attorney will be made aware of that after it is received by the circuit court, okay?
Yes.
Bond is set at 5,000, 10% with GPS tether, correct? And a no contact order. That will continue any additional matters for the record.
Nothing from the people, Your Honor.
I have nothing additional about Mr. Edwards, Your Honor. Thank you.
Anything for you, any questions?
No.
No, set. Thank you. You too.
Okie dokie, friends, TCF Live, Super Friday, episode number 300. Let's go back to Judge Anzalone.
615 FH in the matter of the people of the state of Michigan versus Cody Ryan Cousineau. I have Rhonda Underwood appearing on behalf of Mr. Cousineau. And Mr. Cousineau, this is the date and time set for sentencing. You were able to have a breakout room with Ms. Underwood. Have you had an opportunity now to review the pre-sentence report?
Yes, Your Honor.
Have you had enough time to speak with Ms. Underwood?
Yes, Your Honor.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, Your Honor.
All right, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
Your Honor, just on the front page, unfortunately, I don't make the big bucks. I'm not retained.
Well, you're worth every dime. You should make the big bucks, but I'm gonna make sure that says court appointed, all right?
Thank you.
Okay, all right. Anything else?
Nothing else, Your Honor.
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
I do not believe it does.
The probation officer has computed the minimum sentencing guidelines to be 0 to 17 months. Do you agree with that computation of guidelines?
I would not challenge that.
All right. Before the court passes sentence, is there anything you'd like to say on behalf of your client?
Just briefly, Your Honor. Mr. Kuzno joins us from Bear River Recovery, where I've spoken to him this morning. And Your Honor, he looks great, he sounds great, and he is really, I think, taking to heart what they're doing for him there. He enjoys very much being out of the environment here. And he said that he was very appreciative of Ms. Teskey for recommending it. And he's putting it to good use, Your Honor. I think the recommendation is on point, Your Honor. I think this is an opportunity for Mr. Kuzno to build on this, to complete probation, and to go on and have a successful life, Your Honor.
Excellent. All right. Anything you want to say on your own behalf, Mr. Kuzno?
I just want to thank Ms. Teskey for recommending Bear River. I really do enjoy it up here.
Excellent. Are you learning a lot?
I am. Yeah, they got me in 4 classes every day, and they serve you good food here. So
That's important. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for affirmation, vindication of the law, and protection of society. Sentence of the court will be placed on probation for a period of 2 years. During that term of probation, you will obey and comply with all the articles in your probation and provisions. There is $750 in court costs, $130 crime victim assessment fee, $68 in state costs, $30 per month supervision fee, $60 if you have to put a tether on you. Obviously, one of your terms will be not to use any alcohol, not to use any illegal controlled substances, and report as required. Anything else? Ms. Teskey's gone. All right, so we are going to mail to you somehow your notice of right to appellate review. I am going to give them to you now. So if you call us and say, I want to appeal this, we will process paperwork for you. Obviously, sometimes it's hard to mail stuff off to rehab facilities. So you do have a right to appeal the sentence. When you get the paperwork, there's one copy to initial and date. The other copies are for your records. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Make sure you sign a release so Ms. Teskey can access information at Bear River. And then also, you might want to give her a call, okay?
okay. Yeah, I just spoke with her yesterday, but yes, thank
All
you.
right, excellent. All right, so good luck to you, sir. Thank you.
Thank you.
Good luck.
Bye.
Bye.
All right, Ms. Underwood, you have James Caldwell. So you want him brought down? All right. Hi, ladies.
Okie dokie, friends, we might check back there later, but let's go back to Judge Collada in Ohio.
Smulgan?
Your Honor, we're here in the matter of the State of Ohio versus David A. Sanders, Jr. This is case 26 CR 583. Mr. Sanders is present in court. He is accompanied by his attorney, Mr. John Fatika. We are here set for arraignment.
Fatika?
Good morning, Your Honor.
Morning.
Mr. Sanderson received an indictment, has been so for more than 24 hours. We'd entered not guilty pleas as to each count and respectfully request to be heard as to bond.
Thank you. Mr. Sanders, you received a copy of the indictment?
Yes, sir.
Did you have a chance to go over it?
Yes, sir.
You have the right to have me read that. When did you get it?
Yesterday morning.
You have the right to have me read that to you if you want, and I'm happy to do that, or you can waive the reading, which means I won't read it to you. What would you prefer?
We can waive it, sir.
Very well, then, as to the 2 counts in the indictment charged you with domestic violence, felony of the 4th degree, and aggravated possession of drugs, a felony of the 5th degree, what is your plea to both of those counts?
Not guilty, sir.
All right, a plea of not guilty will be entered on both charges. As to bond, let me hear from the state first. Ms. Mulligan, what's the state's position?
Your Honor, the bond set in the municipal court's $250,000 cash surety or 10%. We understand that to be a bit excessive. The state would be recommending $25,000 cash surety, 10%. Mr. Sanders does have a prior felony record and some failure to appears. He has been to prison 2 prior times.
Give me a second, please. One of the conditions in municipal court was also electronic monitoring house arrest. Are you recommending that?
No.
Sorry?
No, I am not.
What about a no contact order? Are you recommending that? That wasn't part of it initially.
It's not part of the current bond, and the victim does not wish for a no contact order.
Mr. Fatika, you want to be heard on bond?
Thank you, Your Honor. We acknowledge that Mr. Sanders does have prior history. He's 35 years old, works as a laborer. If released on bond, he would reside at 9010 Portage Point Drive, Apartment A in Streetsboro. He lives there with his wife, the alleged victim. She testified at the preliminary hearing that there was no contact between Mr. Sanders and herself on the day in question. Mr. Sanders has been in the Lake County Jail for 50 days as of today. We're asking that he be given an opportunity to get out on an OR bond with the understanding that he's going to seek treatment, get back to work as a laborer, maintain the home. His wife, I think, is scheduled to serve a jail term. And if he got out, he'd be able to take care of their dogs, again, maintain the home, and come back to court employed and well on his way in treatment.
What's the connection to Lake County here?
I'm sorry, I did not hear you.
What's the connection to Lake County? They live in Streetsboro. How does
They were here
okay.
visiting.
I'm talking to the prosecutor here. All right, bond's going to be set at $25,000, reset at $25,000 cash surety, 10%.
Thank you, Your Honor.
Next case, Mr. State versus Lee Butler. You can approach.
Thank you, Judge.
State of Ohio versus Lee Butler, 26 CR 433. Mr. Castro, on behalf of the state.
Good morning, Your Honor. Yes, we are here for arraignment on case number 26 CR 00043. Mr. Lee Butler is here with Attorney Chad Mulkey.
Thank you. Mr. Mulkey?
Thank you, Your Honor. May it please the court and counsel, we will acknowledge receipt of the indictment more than 24 hours ago, waive defects in time, manner, place, and service of that indictment, waive its reading in open court, enter not guilty pleas to all the counts contained therein, and then ask to be heard on bond when appropriate, Judge.
Thank you. Your Lee Butler?
Yes.
Did you receive a copy of this indictment?
Yes.
You had a chance to look it over?
Yes.
When did you get it?
Day before yesterday.
Okay. You have the right to have me read it to you again, and like I said before, I'm happy to do that, but you can also waive the reading. What would you like at this time? Waive it? Very well, then, as to the 4 counts set forth in this indictment, what is your plea to those 4 counts?
Guilty.
No.
Not guilty.
Accept a plea of not guilty at this time to each of the 4 counts, and I'll enter the plea. Give me 1 second, please. All right, as to bond, Mr. Castro, what's the state's position on bond?
Your Honor, it was set municipal at 50,000 cash surety on F5 possession as well as misdemeanor. We would not oppose a reduction on that bond. Speedy time has been waived, and it was filed earlier today.
Mr. Mulkey, what's this defendant requesting here?
Yes, Your Honor. Respectfully, the defendant is asking this court for a recognizance bond. I explained to my client what all that means, including a new felony 4 charge for failure to appear. I conferenced with him about his means to get to court, since a majority of these charges involve OVI. He indicated that his son and daughter both have the ability to drive him to court. I've been in contact with both of them, his daughter yesterday, his son today, who showed up at the lobby of the sheriff's office. So he can get to court. He resides at 1501 East 191st Street, or East 191st Euclid Street in Cleveland, Ohio. He's 67 years old. He does have a criminal history, unfortunately. I do want the court to be aware, it does appear he has a pending case in Cuyahoga County for CCW, but it's my understanding they don't have any intentions to come and pick him up, as it were. Should he get a recognizance bond in this case, they're going to allow him sufficient time to deal with our matter here. He does
So there's not a warrant for him?
No. He indicated there's not.
Okay, well, okay. Just asking.
Yeah, well, I know that's always a concern of the court, that we lose him before we finish our case here in Lincoln. That's not going to be an issue in this case. It does not appear. This is an F5 possession charge, and the OVI is all stemming from the same incident. He's got some medical conditions he'd like to address. He has an issue with his foot. He'd like to make an appointment with his foot doctor, as well as receive care outside of the jail for his other...
Hey, what's wrong? I see you're wearing some type of contraption or brace there. You can stay seated.
Well, I have a back brace, back and neck brace. I was run over by a semi.
You got what?
I was run over by a semi.
Okay.
He hit me and kept going. And for my foot, I got a toe going into my, I got a nail going into my toe. Needs to be clipped, and I usually see my foot doctor every 60 days. And
How long have you been in?
How
long have you been in?
63, 62, 63
Couple
days.
months? Okay.
I came for arraignment March 26th, and I've been here ever since. About 62, 63 days I've been here.
Mr. Castro, was something you wanted to say? I thought,
No,
maybe
Your Honor, I was-
I misread you. I thought you.
No, I did speak with the detective as well on there, and they're not opposed to any kind of reduction as well on this. That he was, as part, with this case, and the reason why I'm special prosecutor on that was resulting from that accident.
Oh, so that's the case that you're a victim on is this case where you were hit by a car?
Yes,
I read the reason why there's a special prosecutor, because you're the victim in another case, correct?
Yeah, I didn't know I had that on me until they cut my clothes off of me.
Don't talk about
But anyway,
All right, the court will reset defendant's bond under his own recognizance with condition, let me look here. Not to drive motor vehicle. You're not to drive any motor vehicle, and you're not to use any drugs, including marijuana. You have to submit urine screens if requested. So when you're released on a known recognizance bond, you have to appear at all future court dates. If you fail to appear at a future court date, that's a separate felony you can be prosecuted for, which is actually more serious than anything you're charged with here.
that'd be no problem.
All right, well, I'm just I need to make sure you understand that
Yes.
if you fail to appear, you can be prosecuted for a felony of the 4th degree, which can get 18 months in prison. So after this hearing, this paperwork's going to get filed, and a judge is going to get assigned. It's going to be one of 4 judges here. That court will then set a hearing date, and your lawyer will let you know when that is. But if you don't hear from your lawyer, you need to contact them to find out when that court date is. It's your responsibility to make sure you know when your court dates are and when you're here.
Right.
They're going to let you know, but it's not their ultimate obligation. It's your responsibility to make sure you find that out, all right?
Right.
Okay. Do you have the paperwork there, the conditions of bond form?
I got the conditions of bond here, on both cases.
Both cases?
On both, yeah, both cases.
He's got 2 cases?
No, no, first
I don't care about that one. But he needs to file the OR paperwork. Okay. All right. Mr. Cashman, anything else you care to discuss?
No, Your Honor, thank you.
All right. Smokey?
Yeah, just for the benefit of my client, when I was conferencing with them, he relayed to me that he has full car insurance coverage, but I want to be very clear that I admonished him to not be driving, and now it is a bond condition that under no circumstances can you drive a motor vehicle.
You understand that?
Yes.
All right.
Thank you, Judge.
All right, thank you.
Alrighty, friends, TCF Live, episode number 300 on this Super Friday. We're approaching hour 3, just about to start that in a minute or so. Let's go back to Judge Anzalone, because looks like her next contestant is coming to her from the Michigan Department of Corrections. So let's see what this is all about.
This is file number 2026-22557 F8. We have matter of the people of the state of Michigan versus Demario Alonzo Cooper. Nope, wrong file. Let me go back to that one. Wait, this is Mr. Caldwell. I grabbed the wrong PSI, I'm sorry. So this is file number 2026-22557 FH in the matter of the people of the state of Michigan versus James Anthony Caldwell. I have Brenda Underwood appearing on behalf of Mr. Caldwell. Mr. Caldwell is present in person. So Mr. Caldwell, make sure you speak loudly for us because our recording system is really bad. So have you had an opportunity to read and review the pre-sentence report?
I did.
Excellent. And have you had an opportunity to discuss that with Ms. Underwood?
I did.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
I am.
All right, very good. Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
Again, Your Honor, on this one, I'm not retaining.
I'm not sure why that is automatically populating, Judge.
I can change that, but that's not something that I personally go in and type. So I gotta figure out why it's doing that.
All right, well, again, Ms. Underwood, you're worth every penny. So, all right, so we will make that change. Ms. Underwood, anything
In
else?
addition, Your Honor, I believe that Mr. Caldwell does have a psychiatric history.
Yes. I didn't hear the first part of yours. Are you talking about on page 1? So, Ms. Teskey, in the body of the report, it does talk about his psychiatric history, but on page 1, it says he doesn't have one.
Okay.
Can we make
Again, I
that-
don't know why that populates, so I'll figure that out, Judge, so we can change that moving forward.
All right, and on this one as well?
Yep.
Okay. Ms. Underwood, anything else?
No, Your Honor, thank you.
All right. Yes.
I'm so sorry. Can we just confirm that prints were done?
Yeah, you guys took him to the jail and he got his fingerprints. Yes, they took him to the jail before they came here. All right, thank you very much for bringing them to do that. Okay. We wouldn't have been able to sentence them without them. All right, Ms. Underwood, the probation department, well, does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not that I'm aware, Your Honor.
Probation department has calculated the minimum sentencing guidelines to be 19 to 47. Do you agree with that calculation of guidelines?
The only thing I would say about the computation of guidelines is the computation of number 9, Your Honor.
Okay, hold on. OB9 or?
Here's what I would say.
Hold on, you gotta let me catch up. Hold on. Let me catch up to you. Let me find it. OB9 is number of victims. So hold on a minute. OB9 is scored at 10 points for 2 to 9 victims placed in danger, or 4 to 19 of property loss. Description. Okay. All right, and it sounds like he was standing in his doorway, refusing to move. The correction officer gave him a direct order to move. He refused to move, pulled a weapon from his pants. Okay, so it looks like there was one correction officer.
Here's what I would say, Your Honor. This is a case where they had him by the taser. I mean, he was just standing there with this thing. I understand why Ms. Teskey scored it. I do. And I respect very much the officers. But I'm not sure there was like a likelihood that someone was going to be hurt.
Okay.
From my client.
So when I read the description of the offense narrative, we do have one correction officer, Vallejo, where he pulled out a weapon from his pants and showed a weapon. I would find that intimidating. So, but that's one individual.
Your Honor, for the purposes of scoring guidelines, I was scoring every responding officer. They all have the potential to be in harm's way when they are trying to apprehend this subject.
Okay. All right. Well, I'm going to reduce that to 0 because he didn't brandish a weapon at any other point. All right. So we will score OB9 at 0, Ms. Underwood.
Okay. That takes us down to 14 months to, I believe 14 months is the low now, Your Honor.
So what is the range now, Ms. Underwood? 14 to?
I believe it's 14 to 29.
14 to 29?
I'm sorry. I'll have to get my book out.
Okay, hold on. I'll look it up. Takes it down to 30. So let me pull up the grid. It's a Class E grid. Let's see. PRVs are 75 and
E-grid
OB is 30. So it'd be 14. I'm looking it up, 14 to 29. All right. So we'll score it at 14 to 29. Okay.
Thank you, Your Honor.
You're welcome. All right. Is there anything else you'd like to say on behalf of your client?
Not on behalf of the guidelines, but on behalf of my client, I would. Your Honor, Mr. Caldwell regrets very much what happened. Mr. Caldwell has certain limitations, and he also has, I think, Your Honor, a thing in his brain that these things, it's not something that he, I believe, intends to do ahead of time. He's very sorry for this conduct. He's very glad no one got hurt, including himself. And I've explained to him that if these things continue to happen, he's going to keep himself in prison. And I'm sure he would like to get out someday. But I think Mr. Caldwell has something he would like to say.
All right. Mr. Caldwell, is there anything you'd like to say on your own behalf?
And I apologize for all the trouble that has been going, that I didn't cause, and it never happened again.
Okay. So, Mr. Caldwell, you're originally sentenced in Wayne County to a 2 to 15 prison term. And then, in 2010, you got assault of a prison guard. 2014, possession of a weapon in prison. 2016, and now this one. And these all stack. You know that, right? So, I mean, if you keep getting these charges, you're going to spend the rest of your life in prison doing short bits. You got it? So, are you going to counseling and taking your medication? Okay.
A verbal response, please.
Could you respond? Yes.
Yes, Your Honor.
Okay. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing, the criteria and reasons for the sentence. Sorry. Are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law and protection of society. So it's sent to the court that you will serve.
I'm sorry, Your Honor. I'm sorry. I'm really sorry to interrupt you, but I just thought, I haven't mentioned yet that there is a copy of the low end of the guidelines, so.
Yeah. Okay. All right. So it sentenced the court that you will serve 14 months to 7.5 years with the Michigan Department of Corrections. You don't get any credit for time served because you were an inmate at the time this offense occurred. There's $130 crime victim rights fee, $68 in state costs, and you will serve this consecutively. Sorry about that. It's just another attorney. So you'll serve this consecutively. So it'll stack on whatever sentence you are serving now, okay? Do you have any questions? Okay. Now you do have a right to appeal this sentence. So my bailiff's going to step down and have you initial and date one copy for our records that you received your appellate paperwork. The other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right. All right. So he's going to bring that down to you and you just initial and date it where he says. Oh, bless you. Bless you. Mr. Mont? Is your client here? All right, I have received back a signed copy of the notice of right to appellate review. Mr. Caldwell, stop doing this, okay?
Yes, ma'am.
All right, you have a good day, Mr. Caldwell.
Alrighty, friends, TCF Live. Happy Friday to all of you. So regarding Dungeon Court, which we normally do on a Friday, I am not certain we will be doing it today. They have not yet started. They've scheduled a stream, but they haven't actually started doing anything. So we'll keep an eye on that. But for now, let's go to Southfield, Judge Sheila Johnson.
Your Honor, Marcus, thank you.
Okay, Mr. Manson, you're here today for a sentencing.
Yes.
And this is on one kind of operating while visibly impaired. So did you have a chance to review the report?
One foot.
All right, what is that?
The first page, summary conclusions, first paragraph, last sentence. Says his health insurance is funded by the government. His health insurance is funded by his employer. Yes, we brought through shit. So I have no additions to the.
Okay. Okay, what would you like to say in his behalf?
Since 2003, this has been a very big eye opener for him. He was in the hospital with this that really messed him up. Should he still has, and he's still suffering some. I think so bad.
Inclement weather, but like other than that, yeah, I'm okay for the most part. Like I've been about the mental part, I just been going to church and carrying myself, doing the best I can do. I haven't had any running since this incident itself. So I've really just been doing my best to like just be my goal at this point is really to be an upstanding citizen, do what I gotta do, so I don't have to look over my shoulders right now. Like I got baptized July 21st, 2025.
Congratulations.
So that's what I've been doing. And I asked him before we got up here, I know I got restrictions, but I do need to go to church. I know I can look at it online, but it doesn't have the same effect as me actually.
But who said you couldn't go to church?
Because my restrictions, I can't,
What restrictions?
my license is restricted.
Oh, okay, that's Secretary of State.
Yeah, like.
So you can't drive to church is what you're saying. But you could go to church.
So that's understandable. I make that happen. But other than that, like in other instances, I stay by myself. I'm out here betting on myself. I'm doing what I'm supposed to do. I follow the law. It was an incident. I came to you guys once I found out as soon as it did. So nobody actually had to come get me.
What happened here?
It was one-off situation. Like I spoke with my substance abuse.
If you say I drink 1 to 2 drinks, I'm small. I don't overdo it.
No, I don't. I don't really drink. I don't.
So then how do you come up with 1 drink, mixed drink, which it could be 1. I don't know what's in a lemon drop.
And that's the one thing I don't recall. Honestly, I don't recall what happened. I don't know if it was something placed in the drink. I don't know what happened. I worked 12 hours that day. It could have been just me being overexhausted or overexerted.
But that wouldn't give you the high bodily alcohol content of 0.15.
And I wasn't drinking a lot that day. Like, I had a problem. I had a problem. I'm being honest. I'm being as honest with you as I can. So I can't even really account for what really took place. That's why I'm still just coming to you.
And then you had an accident too?
Yeah, I did.
That would be.
I fractured my hip. I dislocated 6 bones in the back of the neck.
That's very serious.
It was. But since then, I haven't had any instances where I've come across with any law enforcement where it was any issues where I was drinking and driving. That's not one thing that I would normally do. If I do have a drink, I go home. But I don't normally just drive. I have a drink at my home. and the safety point. By that point, I went out for my coworker's birthday party. Last thing I remember, taking a flash of a picture, and after that, I don't recall anything else.
Hmm. Very strange.
It was already rumors going around, from the common public that like they do have issues with alcohol that they give consumers.
What does that mean? They have issues with the,
Or something.
with the alcohol. What do you mean by issues with the alcohol?
With alcohol or something. So I've seen it several times.
What do you think bad alcohol is?
I don't know specifically what it is because I don't really dwell.
I don't even know what that means.
So it could be like poor quality or like it's not favorable. It's not really like it's fake alcohol or something like that that could cause issues with higher impairments than the normal amounts. At this point, honestly, I just can't.
So you drank one. I've seen people drink them, those like in a martini glass,
I had it in a regular glass.
and it's like a lemon drop.
So I'm not walking around with my.
What's in that? I'm looking at you. You looking like you don't know. I don't know. Vodka?
Yeah,
Ooh.
I drink tequila from time to time.
But that's not in. I don't think tequila's in.
You can actually choose what you want inside of your alcoholic drink. You can have the same thing, same ingredients, the mixtures, but the alcohol substance itself, you can choose what you want. So if you were to go somewhere and say, "Can I get a lemon drop with tequila in it?" They'll substitute the vodka for tequila.
I don't understand it. But then again, that alcohol might be very potent. But you had a 1.15 and had a very significant, like you blacked out.
Yeah, I'm not arguing that.
I think you're on the some of his memories get compromised.
Well, that's what he said. Okay. Anything people wish to say about this?
Oh, yeah.
Okay. All right. Well, you don't have any other history of alcohol-related offenses, but I need to be fairly concerned about what happened here.
I'm still trying to at least get back. I'm taking some time to kind of even try to recall what happened. I still don't have any recognizance.
What about your friends? The ones that were there with you?
I spoke to them. Nobody can recall. So nobody was with me at that point after I left as supposedly I had an accident. So I left on my own terms. I don't even recall leaving. So I took a picture. I woke up in the hospital with a big cast on my leg.
Wow.
Honestly, that's all I remember.
Watching the video, Your Honor, of the police officer.
I don't even recall talking to the police.
I saw, like, actually, he shouldn't have recorded in the firm, but they did. That he was trying to, talk to him and he was not very fortunate.
It almost sounds like somebody, but they used to say in the old movie, slipped a Mickey to him.
I didn't want to say that. I didn't want to say that and just trying to give it like trying to throw that out there. I'm not sure. That's all I had was the one drink, 1 or 2 drinks, and after that I took a picture.
Well, was it 1 or 2?
As I said, 1 to 2. I had one there, and I remember inviting my friend there, and I had another one with them. Now, what I do remember all I remember is being there. We were ballroom. You know how you do the ballroom.
Yeah.
And I sat my drink down. I came back to it. I had a drink, and that's probably whatever happened there. But then I remember last thing, I took a picture and the flash went off, and I woke up in the hospital.
Do you know not to put your drink down in a place?
Trust me, that was one mistake that ruined everything. And that's one thing I normally don't do, but it happened. It happened. We all make mistakes, and that was mine.
I think his actions speak loudly, Your Honor, since he hasn't picked up any other drug or alcohol or criminal activity, no issues with bonds. Any found guy.
Well, that's the best part. All right, well, I think we definitely need to determine probation here just to make sure you're on the right track. And if there's any need for any additional counseling, that we make sure you get it, because the whole circumstance is really questionable as to how, if you drink one, for sure, and unless they put a bunch of different alcohol in, I'm not sure how you got to that level, but but I do think that this warrants some intervention. So 15 months of probation with $600 of oversight fees, $650 in fines and costs, The jail time is a jail alternative. It'll be 4 days credit for one. The other 3 days will be in the weekend impact program. 2 days community service at a nonprofit agency. Also go to the victim impact panel. There will be outpatient substance abuse treatment. Of course, no alcohol or unprescribed drugs. There'll be testing for that. We'll do one AA meeting a week. No driving without a valid license, and do not frequent places where alcohol is served or sold. So we're really talking the bars and the nightclubs and parties, like if they're drinking.
I know this anyway.
Okay. So you can go to a restaurant as long as you don't drink off the wine list. Maintain your job.
No, that's my life. And what I'm gonna keep. That's one thing I do. Yeah, my attendance is perfect. I'm gonna make sure I go to work.
Okay. Pay a $75 statutory crime victims' rights fee and $100 substance abuse assessment fee. Emergency services reimbursement here is $600. Counsel fee $200. And that's going to complete the sentence of the court.
Thank you.
Oh, and if you do finish your terms and conditions, you would ask to get off probation after 1/2 of this 15 months is over. So like 7.5 months. If you think you've done everything, you could ask for the form, fill out the form as to why you want to get off probation. Probation will then send it to the prosecutor. If they have no objection, they'll send it to me. If I have no objection or issue, I'll just sign you off for probation. If we have some questions or reservations, then we would ask to set it for a hearing. We'd all come back and talk about whether or not you should be released at that point. Okay? All right, you're all set.
Thank you. Wonderful weekend.
You do.
Okie dokie, friends, TCF Live. My name is Dan. If you're new to the channel, and some of you out there just might be, do us a favor and say good morning in the chat. We're a friendly folk here, and it's good to have you with us. Let's go back to Judge Collada in Ohio, new contestant there.
Gregorich.
Thank you, Your Honor. Before you today on State versus Darrell Williams, file 25 CR 921. We're here today for sentencing. State of Ohio has had the opportunity to review the pre-sentence investigation report and is prepared to go forward, and the drug and alcohol report, and is prepared to go forward. Thank you.
Thank you. Mr. Smith, any reason not to go forward?
No, Your Honor. I've reviewed the same documents the prosecutor has, and we're prepared to go forward. Thank you.
Is there anything you'd like to say on behalf of your client?
Yes, Your Honor.
Go
My
ahead.
client takes, first and foremost, Mr. Williams takes full responsibility for this matter, definitely realizes his wrongdoing, and he definitely did not make the right decisions in regards to this matter. He's fully aware and acknowledges his criminal past. He definitely realizes that he's made a lot of wrong decisions in his life, but I do believe this time this has been a wake-up call for him. He realizes that he needs to make better decisions in his life for himself as well as his family. In mitigation, he has recently enrolled in the city mission as of beginning May 6th. It's a 6 to 9 month program. He's currently in that program. It'll help him with drug and alcohol treatment, getting himself back on his feet, making better decisions in life, and also getting a job, and also stable housing as well too. So he
Also what?
Excuse me?
What was the last thing you said?
About housing and job.
You said something about the state of Ohio, huh?
Excuse me?
I thought you said something about the state of Ohio.
No, I didn't. No, I didn't.
I misunderstood you, I'm sorry.
No. There is a representative from the city mission here to speak on his behalf. Mr. Williams fortunately has not had any run-ins or brushes with the law since you let him out on bond since we were here last time. But he's definitely learned his lessons here. He knows that he needs to fly straight and make better decisions for him and his family, and he's willing to do that. So we're just asking for probation in this matter, Your Honor, finding court costs. If you also consider credit for time served. Like I said, he's fully remorseful in the situation. He definitely realizes he needs to make better decisions in his life. Thank you.
Thank you. Did you want someone to speak from?
Yes, I don't know if you want to see this paperwork again, or do you want to go ahead, Coach.
Sure.
Sir, if you want to come on.
Well, whoever it is that would like to speak, you can stand right where it is. You can stand right there. Just keep your voice up. State your full name, spell your last name, and then say whatever you'd like me to know.
Sure, my name is Raymond Mills, that's M-I-L-L-S. I'm the intake coordinator at the City Mission Crossroads. And I just wanted to come on behalf of Mr. Williams to state that he has been fully compliant with our program components. As you can see in that document, we have 4 phases: the arrival stability phase, the personal development phase, the work readiness phase, and the employment and housing phases. So in those phases, of course, we have support groups that deals with the issues that Mr. Williams has. We have a resource center that helps our men with trades or getting Tri-C school and ultimately get jobs. We have DBT, we coordinate with Ohio Guidestone in regards to mental health and IOP, in addition to Joshua Tree, which is another agency that we deal with. We also link our men up with Carmela Rose, so that if there's any insurance issues that they may have in regard to health insurance, we have Metro Health that comes on and help our guys with health situations. So there's a host of resources that we have for our men so that they can become more productive members of society. And thus far, coming in, Mr. Williams, he communicated a lot of his struggles to us, and that's the first step, like living up to whatever part that you play in any situation that you get yourself into. And he's been willing to take what comes with whatever he's done. And one of the things, he came in willingly, not through the courts, not for the courts. He just wanted to turn his life around, and we've been able to communicate those things with one another. So he's been fully compliant to all our program components thus far, so I can speak to that.
How long is this program?
It's a 6 to 9 month program.
So what determines whether it's 6, 7, 8, or 9?
Well, it's once that individual moves on to another case manager, they have what they call an individual service plan. And so by us helping all people opposed to just generalizing with one group of people, that's what determines the 6 to 9 month program. Some men come in, they have legal issues that we'll accept them where no place else will accept them. So that stay may be a little bit longer. Some people come in with disabilities, not so much physical disabilities, but where they're not able to work. So getting housing for them may look a little bit different. And then we have our employment phases where some of our guys come in, such as Mr. Williams, who don't have those type of issues, who deal with the issues that he have now. We just need to, we just need that transformation to take place through our program.
But it's a minimum at 6 months? At minimum it's 6 months?
The minimum of 6 is 6 months, yes.
And are they residing there?
Yes,
the whole
it's
time?
residential, yes it is.
The whole, at least for the 6 months?
For the 6 months, there's no overnight stays or anything like that. You have to be there every night. We have a curfew. We have programming hours throughout the course of the day. And once your programming hours are over with, if you have, but we don't hold our men back from any court situations or if they have to see probation or if they have doctor's appointments. If there's a family emergency, then we'll take in consideration whether or not that person could potentially stay overnight or anything like that. But it's a 6 to 9 month residential program.
And what if they don't show up at night? Then what happens?
Well,
I mean, let's assume you look into it and there's nothing legit. There's no.
If it's not legit, then it's a case by case situation.
I'm assuming if someone's been there for 5 months and they've done well, they may get a little more consideration.
Yeah, they'll get a consideration. So what I try to do is I try to make sure what we don't want to do is turn people back to the streets. So if it's, for instance, if it's a situation where there's a relapse that occurs, so we'll literally, we'll try to have that individual get in contact with the probation or parole. And we'll get that person into where they can get the level of care that they need for whatever that situation is. So they might transition to another program from there. If they stay out, I'll try to find them someplace else.
How many people are there related to court cases versus not the legal system?
I couldn't give you an accurate number, but I'll say maybe 50%.
50-50?
Maybe 50-50, yeah. 40, 60.
Do
maybe.
you work with the courts? So if someone's on probation and they're not doing what they're supposed to be doing, do you guys notify the courts?
No. That's we don't necessarily, but if the courts come to us, for instance, if that individual isn't there anymore and his probation officer or parole officer comes to visit us or to visit him at our facility, we'll let him know that he's not there. You know, but as far as us communicating back and forth with
So if the person takes off and they're no longer there, you're not going to notify the probation officer that this person's not there anymore?
No.
So how do the courts find out if the probation?
It normally happens.
What normally happens?
They find out. At some point, they'll find out. Now, now there are cases where there's release of information that we have to, there's HIPAA laws, of course, that you know of. Now, if there's a release of information, once they come to us, and the probation officer, they give us, we get a release of information that we can give to whatever probation or whatever legal system that, then we'll notify. But it has to be through a release of information.
If they send a release, then you'll take the affirmative step of notifying. You're not going to.
Absolutely.
You're not going to make the probation department reach out to you to find out how they're doing.
No, we could, like I said, if there's a release of information and I'm able to contact that whoever that individual is that needs to know that they're not there anymore. No, we don't have a problem with that.
You'll do it, not that you.
Absolutely.
But I mean, you.
Yeah.
So the person that takes off, they're no longer there, and there's a release of information signed. You'll take the affirmative step of contacting them.
Say, hey, that individual, John Doe, whoever that individual is, we'll take the action of contacting the proper authorities and letting them know that that person isn't there anymore.
Okay. All right. Thank you, Mr. Mills.
Sure.
Is there anything else? Is there anything else you wanted to say? I'm sorry.
No, other than he's been compliant to everything that we need him to do. That's all I can say.
Okay. Mr. Williams, you have the right to address this court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, Your Honor.
Good.
May I say?
Whatever you're comfortable doing.
I want to apologize to the court for the time I wasted by doing what I did. I take full responsibility for the part I played, and I thank everybody in here for the patience and the time y'all had with dealing with me, and I take full consideration on the part I gotta play to make this better and make this not a waste of time to everybody. And I thank y'all.
All right, thank you. Mr. Smith, anything else on behalf of the defendant?
Yes, Your Honor. I do believe, again, Mr. Williams is on the right track here, especially engaged in this program. He definitely acknowledges his wrongdoing in this matter and that he's made, in the past, wrong life choices, and he's ready to, to confront all that and just start making better decisions in his life. Thank you.
Thank you. Mr. Geigers for the state.
Thank you, Your Honor. The state of Ohio would trust the court to fashion a sentence that would be appropriate in this manner. The only question with the reporting aspect from city mission is there a person who would be responsible for that this court could hold accountable if the court is not informed that he left or something like that? Thank you.
Hey, Dave, can I see you for a second?
So we're going to mute him for a moment because he likes to put on that static sound when he mutes, and that's no fun. Last half hour of TCF Live. I want to take a moment while they're talking and thank everybody for their generosity today. It means a lot to me that we got to 300 episodes of this live show, and obviously so much more on this channel beyond just the live, but this is my favorite part because I get to interact with all of you and the community that we've built here, and it's just been super cool. So thank all of you for all of the time that you've given me. Those of you who, all of you pay me with your time. and you certainly don't owe me anything. But I just want to let you all know that however you interact with me, it is very much appreciated. So thank you. We are a couple of minutes in the Wayback Machine here, so let's see if we can bump forward past this little sidebar chat. That was probably too far. Okay, let's continue.
This court has reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the offenses involved, the nature of the offenses. I've considered what's been said here in court by Mr. Smith, the defendant himself, Mr. Mills from the city mission, the prosecutor. The paperwork that was submitted to me. I'll give this back to you at the end. You can get it at the end. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating it's more or less serious. Recidivism factors, the court finds the defendant was on probation at the time he committed this offense. I was on probation at the Cuyahoga County Common Police Court. In fact, there was a warrant out for him at the time for a probation violation because he failed to appear when he committed this offense. He has served multiple prison terms before. He's been put on probation many times before, and he's violated his probation on multiple occasions, so he's failed to comply with previously imposed sanctions ordered by courts. Failed to appear for a hearing in this case, and there was a warrant issued for him for some time before he finally was arrested on that. As for factors indicating recidivism is less likely, the court will note that the defendant voluntarily put himself into this program at the city mission. He wasn't ordered to do that. And it wasn't, we'll just see sometimes done just 2 or 3 days before the sentencing. It was done, what are we, about 3 weeks now, 3.5 weeks ago? I think May 6th, if I'm remembering correctly.
Yeah, May 6th, right.
Under 29-29-13B1, the court finds defendant has previously served a prison term and was on probation. That overrides the presumption for community control, permits the court to impose a prison term with the defendant's history. And it's a lengthy history. It's a lengthy history of drug trafficking, which is what we're here for. Prison is certainly consistent with the purposes and principles of sentencing. But Mr. Williams, I'll give you one chance here. It's a short leash. I mean, with your history, I can easily justify a prison term, especially with dealing in drugs, and that's what your history is here. But I'll give you a chance to complete what you started. I'll find you're amenable to community control sanction. I'm going to put you on community control sanctions for 2 years. I'm going to order that you serve 45 days in jail with 45 days of credit. I'm going to order that you continue and successfully complete this 6 to 9 month program at City Mission. So a minimum of 6 months, up to possibly nine months, whatever's being recommended there. You are to sign whatever releases are necessary so that they can communicate with the probation department. That needs to be done immediately. Again, you're to successfully complete that program and follow whatever aftercare recommendations they make. You're not to use any drugs or alcohol. That includes no marijuana use even. You're to submit random urine screens when requested to the probation department. They have to be negative. A positive screen will result in your probation being terminated. You understand that? You're not to screw around with urine samples, bring in fake urine, someone else's urine, anything like that. That's even worse to me than, quite frankly, testing positive. I'm not going to order any specific number of AA meetings, whatever's recommended by the folks at the city mission. If they recommend any, then that'll be a condition of your probation as well, to do whatever number of AA meetings a week are recommended, if any. You're to obtain and maintain full-time employment. You are to report to your probation officer as directed and/or maintain contact with them as directed. So while you're at city mission, you're still going to have to report, but they may have you report sometimes and then, but maintain daily, or not daily, excuse me, weekly phone contact. But however whatever they're requiring in terms of contact with them, you need to do that. If you fail to do that, you're going to be in violation.
Yes, Your Honor.
And you're going to need to follow the rules at the city mission here. It seems like you're doing all right so far, but you need to follow the rules and not get into it with other people. I know there was some issues when you were in the jail here with whoever was in your pod, and I'm not getting into that. I'm not pointing, but I know there was issues there. You're going to have to deal with that with other people and get along with other people and remember what you're there for. If there's issues there that cause you to get kicked out, you're not going to be pointing the finger at someone else and saying, this wasn't my fault. It's going to be your fault if you get kicked out.
Right.
Here, court crossing supervision, please. I may have said that, but if I didn't, do that. Count one will be dismissed as agreed to. Bond will be released. You still have the bracelet on?
Yes.
We'll have to make arrangements to get that taken off.
Okay.
Mr. Tompkins, anything else I should be considering here or thinking about?
Judge, we just asked for a mental health assessment as well.
And we'll do a mental health evaluation and follow whatever, if any, recommendations for any type of counseling or treatment. If they recommend that you go see someone, you gotta do it. If they recommend medication, you gotta do it. If they recommend anything, then you're all done there.
Okay.
Understand that? And the full-time employment is whenever it's, folks at city mission say, I don't want you going back saying, they say I need to work today, and so I can't do any of this stuff. It's whatever pursuant to their orders, and then once you're done, you're obviously working full-time.
Okay.
Mr. Mills, anything else I should think about?
No, that's fine, Your Honor. We'll make sure that he has a mental health assessment. We have an agency that we
I assume they can do that.
We'll make sure we get that. I'll get a referral out for that right away.
And I'm relying on you guys, when he signs this waiver, to keep Mr. Tompkins up to date with what's going on.
We will, sir.
All right.
Yeah.
Mr. Williams, do you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could extend your probation up to 5 years. Up to 5 years. I can impose more restrictive sanctions against you, including local jail time, or I can. And what will happen is again, you're on a short leash here with your history. I'll terminate your probation, send you to prison. And if I were to send you to prison, it would be 18 months on each count that you pled guilty to consecutive. So 3 years in prison is what's hanging over your head. You understand that?
Yes.
And that would be consecutive to any other sentence you may be serving for some other case, if there is any other case that comes up or that you're being sentenced to at that time. I also want two more things. You need to clear up this outstanding warrant you have in the Cleveland Municipal Court for a traffic offense.
Okay.
You can't be on probation and having outstanding warrants out for you, so it's a more recent case, a 25 case. You familiar with it?
Mr. Tompkins ran it by me
It's
already.
operating a vehicle without a valid license. It was
Yes.
just in November, Cleveland Metro Parks.
Yes, I just been down on money, so I know it was gonna take some money, so I was just waiting until I got stuff on track.
You need
but
to take care of it
I'll
so you
get
can clear
taken
up, so
care
that
of.
warrant at least is cleared up.
I got you.
And then the other thing I'm gonna order, I'm not suspending your license, but I'm ordering that you do not drive without a valid license or valid privileges.
Okay.
So if you get stopped driving a car but you don't get cited for DUS, you're still in violation of your probation.
Okay.
You're not to drive a vehicle without a valid license or valid privileges. You understand that?
Okay.
So if sometimes you get behind the wheel of a car and say, oh, what's the big deal? I get caught, it's just no operator's license. It's 3 years in prison if you get caught driving a car. You
Okay.
understand?
Yes.
All right. Mr. Smith, anything else for the record?
No.
Mr. Gagorich?
Costs and fees, Your Honor?
I think I said it twice already, maybe.
Oh,
And
did
I
you?
also said it at least once, because I thought I repeated myself.
Oh, okay.
But yeah, costs and fees. Yep, thank you.
All right.
Okie dokie, friends. We have reached that time on a Friday. They only streamed a few minutes this morning, but a few minutes is all we need because a few minutes is all we have left. It's that time where we learn that Appalachian justice is best served in a cold, dank basement where the carpet is blood red. The lighting is from Soviet-era Cold War war rooms. The judge is cranky. The printer never stops running. The souls of the dead can be heard crying out in the background. And honestly, I am not sure that I'm kidding about any of that. If you are new to this channel, this is our Friday Guilty Pleasure. Ladies and gentlemen, I give you Dungeon Court.
I got everything done but the driver intervention program?
Yes, from our last court date in May, that day I got online and tried to do it all, and I got it all squared away, but the fastest I can get in is July 16th to the 19th, and I've already paid for it.
You're going to one local here in Lawrence County?
Yeah.
Okay. Well, I'll set your date after that, and then if you get it completed and they turn in, which they will if you go there.
Okay.
Then you don't have to show up, because that's the only thing you got left to do.
Okay.
So I'm going to set it for July 27th. We just check in to make sure it didn't get filed. If you complete and it's a good report, your case will be finished at that time complete.
All right, thank you.
You're welcome. That's 9 a.m. July 27th. Brittany Valco, 24-144, she's not here.
No, I believe she's on Zoom.
Okay, she's on teleconference. Okay, I see her. All right, you still have community service to do.
Your Honor, if I may, on April 16th, Ms. Valco's order to do community service is not in here.
Okay. Tell me about that. Why haven't you been in to do community service?
I had surgery on the 14th and I couldn't come in.
Okay, are you still?
And then I was in from April 5th to the 9th, and then from the 14th to the 19th, I was in the hospital, and then from the 6th through the 11th, I was in the hospital, and I was cleared last Wednesday to go back to work.
Okay, so give me a date when you're going to be out for community service.
I can do it, not tomorrow Saturday, but next Saturday.
Okay, so that is going to be June the 6th. So we got you down.
And I'll also be able to make a payment next Friday, not today, because I just went back to work last Wednesday.
Okay, I'm showing $435 as your balance. Okay, I'm gonna set you for your next review hearing. Does it matter what day of the week it is?
No, it doesn't.
July 3rd. That's a Friday. July 3rd at 9 o'clock for review.
Okay.
Mark Bell, 24/8/26 is here. He's got a report. Okay, you're working, you got a job now?
Yes, I should be starting this weekend.
Okay. You have done some community service since your last hearing?
I thought I knocked it all out.
Yeah, you can work extra toward your fines, you can't pay.
Okay, okay, I think I'm gonna just pay them off eventually.
Okay.
Yep.
I'll set you for July 3rd also.
All right.
July 3rd is your next hearing. If you get it done by then, you don't have to come back.
Okay.
July 3rd, 9 o'clock.
All right, thank you.
You're welcome. Jeremy Bugner. Okay. Yeah. Okay, you got a letter of completion and a certificate of completion with a copy. Give you the original back.
Oh, she did. I'm sorry.
Okay. Report. Still have community service to do, and you've got fines to pay.
Yep, made a small payment this morning on the fine, and I'll be here tomorrow for community service.
Did you pay online then?
Yes, sir.
How much did you pay?
It was only 20.
Okay. What about your community service?
And then I can be here on Saturdays, so I'll be here tomorrow.
Okay, very good. What about your work schedule?
Monday through Friday.
Does it matter? It's
So
Mondays or Fridays or when we set things?
either or.
Okay. He says he'll be here tomorrow too for community
Yes,
service.
sir.
Jeremy Bogner. I'll set you for July 10th.
Yes, sir.
That's a Saturday, or a Friday. July 10th, Friday, is your next hearing, 9 o'clock.
Thank you, Your Honor.
You're welcome. Good job on your counseling.
Thank you.
Keith Carpenter, 2862. Community service is done. Work on your fines. You made a payment earlier this month.
Yes, sir.
Okay. Okay, you're a newer case, so I'm going to set you for July 17th. It's your next hearing, July 17th at 9 o'clock.
All right, thank you.
You're welcome.
State of Ohio versus Tim Fortner, Russell Kimbrough, Marissa Polly, Elena Pennington.
And Fortner is here.
Yes, sir.
Yes, John. 25301 and 25709. You've got community service to do.
Yep.
Your Honor, if I may, on April 20th, Mr. Fortner was ordered to do some community service before his next hearing. He is not willing.
Okay, what's your explanation on that?
Well, I just got a job, and today's payday, and I've just been busy working, and my mother-in-law's had cancer in Columbus, and I've been taking my girlfriend back and forth to do some of her chores up there. It's been a mess, Your Honor. But
So you're telling me
I'm coming in tomorrow.
5 weeks you couldn't get one day to do community service?
Food is so costly and back and forth, yes, Your Honor, it's been
Okay,
hell.
back in Holdingsville.
What is it?
You're going into custody. You're ordered to do community service, you didn't do it, you got a bunch of lame excuses why you couldn't do it. Not buying it. Because community service is in lieu of jail. If you don't want to do community service, you're going to jail. folks. You need to be a little bit afraid of that. Russell Kimbrough. Okay, he's not finished and he's not here, so he actually, I'm going to delay because he should be on the sentence, and he's actually a sentence. He's got a bond up, so I'm going to hold him until the end. Maybe he'll come later. Marissa Pauley, 25,613. Community service done. You've done extra towards your fine. And you did the 3-day school a long time ago. Okay, you're making good progress. So, Mondays or Fridays, does it matter which days you come back?
Fridays will be better.
Okay. I'll set you for July 10th. 9 o'clock. Okay.
Thank you.
Keep working at it. If you get it done by then, you don't have to come back.
Okay, thank you.
Liam Pennington, 16,1593, you're just working on getting your fines paid.
Yes, and I have a payment today,
How much are you gonna pay?
20.
Okay. We're getting there.
We're getting there.
Slowly.
Yeah.
Okay, go see the clerk for your payment, and I'll set, I'm gonna put you on Monday, is that okay?
That's fine.
July 20th is your next hearing. It's a Monday, 9 o'clock.
Thank you, Your Honor.
See the clerk.
State of Ohio versus Christopher Roadcat, Mason Sly, Donald Wilson, and Justin Thomas.
Christopher Roadcat.
Yes, sir.
Case number 21-1172, 23-646. Okay, you have a payment on your fines?
Yes, I do.
How much are you paying?
20.
Okay. See the clerk. I'll set you for July 6th, 7/6/26.
Thank you, sir.
You're welcome. Mason Sly is 25,484. He's at RRS. Okay, so you're asking he's moved out of the area and asked to complete counseling with another agency. Where you live now, sir?
Camden, Ohio. It's about 3 hours away.
What's that close to Camden?
More like Indiana. Like I'm about 20 minutes away from Indiana, but I also got a better job opportunity up there, and just to get out of the area, I thought it'd be a good decision.
Okay, well, you still have 4 days of community service.
I'm gonna be down this whole weekend, so I'll be here tomorrow.
Okay, so you get it done, but he's not finished, you're not saying he's finished, he needs to complete treatment, or?
We're okay with him completing if you're okay with him going up there.
All right, well, just finish up your community service, and then you won't have to come back. And I'm gonna give you a day, because people tell me they're gonna finish, and then they don't do it. So I'll give you a date that you gotta be back, but if you finish your community service, your case will be completed.
I appreciate it.
So let's make it, July 20th. That gives you plenty of time to get it done.
I appreciate
You're
it.
finished, you're finished service, you don't have to be here. Good luck to you.
I appreciate it.
Donald Wilson Jr. 07, 27, 23, just paying off fines. Do you have a payment, Mr. Wilson?
I made 2 online since I was here last.
Okay. Let's pull my.
I believe one was for 40 and one was for 65.
Okay, it was May 5th, $65. Okay. Next hearing,
Fridays, please.
July 3rd.
Thank you, sir.
You're welcome.
Well, friends, to be honest with you, we heard better cries in Judge Collada's court today than we did in dungeon court, but sometimes that's how it works out. Thank you so much, everybody, for everything that you did for me and for this community today. Thank you for showing up, sharing your thoughts in the chat, telling me how much you love me, all of that. Very much appreciated. This has been fun, this ride to 300 live shows and countless hundreds of videos beyond that. What are we're creeping up on 2,500, 3,000 videos, something like that on this channel. I've lost track. But it's been an honor to do this. I look forward to doing it as long as the Lord lets me. So I appreciate every one of you. Go have yourselves a good weekend. We will be back Monday, 9 a.m. Eastern, 6 a.m. Pacific. If you are a brand new channel member, you get to join us a half an hour early for the pre-show, where we don't necessarily talk about court. We generally just have fun. So please do join us for that. Look forward to seeing you all soon. Again, have a good weekend. We'll post some stuff throughout the weekend, so keep an eye out. But take care. God bless.